You're live.
We are. Get yourself see it. You're live. It's Friday, May 8th, and happy May 8th. Happy Friday. Today is our deadline day, and the Pro Tem has really asked us to make concerted efforts to get our work and our response to the initial bills that have come to us from the House out today. And we're as a team going to try and honor that. So we have three bills that are the last three bills that are kind of what I would call the crossover bills. The other bills that we still have to look at, S230, S328, S327, all are bills that we have some time. We have next week to look at. If we can get the last three remaining bills voted out of this committee today, that would be great. And we have first our landlord tenant bill, which has come to us from Senate Judiciary, and our ledge council is going to go through what was accomplished by Senate Judiciary. And I think we have one patch that Chris Donner is going to talk with us about, and we're going to try and fix. So Cameron, when you are ready, we are yours. So Keisha had said our deadline today is we're trying to get all the crossover bills out. We have three remaining: landlord tenant, manufactured homes, and the housing, the rural financing housing bill. So those are the three we're going to try and get out today. And then hopefully we have time for Rick we can hopefully land 211, the data broker bill, and because we're close to finishing that, and then really look at 71, S71 with the Connecticut updates. So that's the objective today by 11:25.
Oh, I thought we're gonna look at that.
We're going to begin. 71 is a big bill.
Okay.
And we haven't touched it.
I just can't imagine we get to that.
Hey, you know what? I'm going to live in hope.
Okay. But we're not required to get to that.
We're really being asked to get the first three out.
Yeah.
So that is the objective. Good morning, everybody. It's good to see all these advocates and our Cameron. So Cameron, if you would be kind enough to share with us what Judiciary did.
Yes, ma'am.
And I think then Chris is going to explain the thing that was missed that Notter agrees with. So
I'll get to that when we get there.
So we're here.
So let's see.
So you have in front of you draft 5.1 from Judiciary of 772.
Yes, ma'am. So this
Thank you,
is the for the record. For the record, Cameron Wood, Office of Legislative Counsel, would have as mentioned, draft 5.1. This is the report of the Senate Judiciary Committee with their recommended proposal of amendment to H772. I'll start to walk through the language. But before I get there, the Judiciary Committee made some amendments throughout, small amendments throughout, to accomplish the most substantive change they made was they took out the changes to the termination notice periods in Title IX. So if you all remember when we did the initial walkthrough, you have the requirement to terminate the rental agreement first, and the landlord has to provide a certain notice period. And depending on the reason you're terminating the rental agreement, there is a different notice period. There was that breakdown chart that I gave you all. Separate from that, if the individual tenant remains in the property after the period, after the termination of the rental, then you have to bring an ejectment action in court to get a writ of possession to remove that individual. There were changes in the bill as proposed by the House to both of those aspects of the ejectment process, shortening in some instances, lengthening in other instances, the termination notice period, and then creating new ejectment subchapter for certain ejectment reasons, for certain termination reasons. All of that has been pulled out of the bill. So the changes to the termination notice periods All of that has been removed. And then,
including, just for a substantive discussion, all the dangerous tenant, the violent tenant that benefited from our testimony and what we heard in here that benefited both landlords and tenants. That has all been stripped.
the shortening of the notice period for the breach of the material terms of the rental agreement or for criminal activity, acts of violence, etc., that was removed.
And has been put in the study that the courts were asking the court to do.
Yep, and then the expedited process on the ejectment side, that was removed and it's been put into part of a study or a report back from the judiciary about how to create a dedicated housing docket to be able to address ejectment cases within all of them within 90 days.
Right. So it hasn't disappeared, it's just
Right.
gone into the work of the court in conjunction with all the stakeholders.
Right, so now I'm gonna run through what you have remainder here.
And if I could just say, there's so much that's still substantive on the landlord tenant side. We'll have to walk through each piece.
No, the no
pretty
trespass,
carefully.
well, there are just three things that are left, the no trespass and the good Samaritan.
So
If am I reading draft 5.1,
Yeah.
there's security deposits, there's rent increases,
I know
there's,
Cameron's gonna go through it.
Yeah.
I just don't know that
Yeah, no, but the
we're
three
gonna be
big things,
done with this.
those are the three
in
big
an
things.
hour.
So there's a lot of pieces here that still address changes in the residential rental agreement chapter. And the judiciary committee left them for you all as to, whether or not to amend. They made certain technical amendments that I'll mention, but what is remaining here is, the judiciary committee wanted to leave for this committee. So first thing, definitions. There was a definition of immediate family that's been removed because they removed the, as I mentioned a second ago, the termination notice section, the periods. There was an expansion to allow a landlord, if they needed to repurpose the property or they wanted to allow an immediate family member to rent the property, because that's been removed. You no longer need the definition of immediate family, so that's been struck.
Okay, those are not in the definitions in section one.
It was removed. The
Yeah.
definition of immediate family is no longer there. So what you have left is the definition of domestic abuse, protected tenant, sexual assault, and stalking. And this is all related to the bifurcation of the rental agreement for victims of domestic abuse, sexual assault, or stalking. That's been slightly tweaked based on the Judiciary Committee report, and I'll get to that in a second. So we get to page 2. Rent increases. This has not been changed. This is where the landlord cannot increase rent more than once in a 12-month period unless the landlord has purchased the building, in which case that limitation would not apply. This has not changed from what was proposed from the House. And so I'm just going to keep going, knowing that you all may want to continue to work through, but in a bit of time, I'm just going to keep moving forward. Okay. So then you get to residential rental application. This is the bottom of page 2. This is where there's subdivision 2 being added to provide a definition for what an application fee is, any fee, charge, or costs. Then you move to top of page 3. Now you have a few subdivisions here, 3, 4, subsection C. This is where the House is proposing to put in that a landlord may charge for a credit check or a background check.
Can I go back to the rent increase piece? The greatest concern I've heard around multiple rent increases in a year has come from senior living facilities. Does the definition of landlord cover that?
Senior housing,
Yeah,
I assume it covers any landlord.
Just want to double check the exclusions here.
Chris, do you know, or Gene?
Yeah, looking at the exclusions, there's a section within Title IX that specifically excludes certain type of, housing arrangements, if you will. I'm just doing a quick search for the definition or for the word senior. I'm not seeing it, so I don't want to answer something on the fly without having a second to double check,
Okay,
but we have to come back.
so let's give you some time to double check it, if you can. When we well, whenever we have a moment, but let's finish with these because I'm,
Okay.
be great.
Circling back to the application, so as I was mentioning here on page 3, it allows for the charging of a credit check or a background check. It has to be actual costs unless the tenant provides a current credit report, in which case the landlord cannot charge. Credit report is defined as something within the past 90 days. And then if charging, you have to provide a copy of the credit or the background check to the tenant. And then subsection C says a violation of this section is an unfair practice in commerce. So a few quick things about this. Initially, the Judiciary Committee removed this language right here on the top of page 2, the C, the 4, and the subsection C. Excuse me, the 3, the 4, and the subsection C. Initially, it was removed. At the very last day, yesterday morning, they put it back in because they felt it probably was more for the purview of this committee to review. So I'm just letting you know that the committee initially had what appeared to be consensus on removing it. And then the last thing, real quick, Senator, the last thing I'm going to mention is my recommendation to you would be to remove subsection C at a minimum, because there are court cases where the courts have determined that violations of the residential rental agreement chapter are or can be violations of consumer protection. And so I think if you added this in, you would potentially be having an unintended consequence by signaling to the court that only this section should be a violation of consumer protection as opposed to any violation of the entire chapter. So based on further research and information coming subsequent to this being approved by the House, my recommendation would be to remove that subsection C.
And I believe this is the section Chris is going to be testifying to us about as soon as you're done. Right.
I'd like to raise a concern about this section.
Yes, that's, they are good.
I think we can strip this section.
Yeah.
So,
Okay, that's what I believe Chris will be proposing. Great.
can I do elaborate? Let's
Yeah.
short.
So is that the format this morning? We're gonna voice objections
Check
as we move through, or?
Well, it's a good question. Our time is limited and I'd really like to move this bill out today if we can, because I'm going to be proposing that we concur with the Senate Judiciary Committee with a further proposal amendment, which is to, I believe, Chris, if I'm correct, strip this section 3.
Chris Donnelly, Champlain Housing Trust, yes,
Right. So both 3, 4, and C.
correct.
Correct. So the proposal is to strip that. Chris is proposing to strip that. And I am, so that, just so as we go through this, that is a proposal and he's going to speak to it.
Yeah, and if each section, we could at least flag, like, if we would strip the section because we don't feel comfortable voting on it today.
I really would like to vote on this today.
No, I'm saying I will,
Yeah.
I'll probably only be comfortable voting if there's certain sections that are stripped. It may not just be that one.
No. Well, we'll see. There's a
Okay.
lot of other, the rest of us too. So, Chris, if we're trying to check off, sections so that we are really being time efficient, I think, so far, I'm fine with everything. Is anyone else fine with it? Everything? Okay, so far?
Oh, so far.
Yeah.
So page 2, rent increases every 12 months. We had this conversation
Yeah,
about
we did. We did.
utilities are included or not. We see a fuel cost doubling.
Right.
So I'm not in favor of that.
Why?
Page 2, line 8, 9, and 10. I'm not sure again how we're gonna
So your
approach this.
rent doesn't go up depending on fuel increase. I mean, those are set for the year.
Has a real possibility of fueling over a period of time.
So
The notion that the landlord can't recover that is I think, unacceptable.
But then they could include it in their rent increase for the next year.
Some
Well,
they don't know if they're
tenant,
gonna-
we don't know the tenant even be there.
some rental agreements bundle utilities, right? So, because they can't split it because it's serving multiple units. So I agree. that
Okay,
this-
I have already flagged this as a section, because we had a question about whether it includes senior landlords.
And I would make it just for senior living if we would otherwise strip it, only because that's where I heard this concern raised the most. I mean, of course, people raise concerns about multiple rent increases, but if we're trying to start with where we agree, the biggest concern I have is when this happens to seniors in facilities that keep getting bought and sold.
I have it for all tenant
Why?
in Vermont because you accept and sign a contract with one notion of that. It's gonna be your rent. And if your contract says it's a year-long contract, then it shouldn't be changed. Obviously, if you're renting month to month, it's a different thing.
Well,
So,
then that would be a breach of contract if they had assigned it.
Right.
The other thing would be an incentive to raise the amount charged for rent starting out, to start out.
but
Right.
If there's no ability to recover major cost
Yeah.
increases.
So we have
Or that.
no agreement on this.
So I don't
That's already
really need
clear.
that in my business.
I would say that's already clear. Okay, let's
Okay.
keep going. Section 3, 4, and C have already been proposed to be eliminated. And is that agreement with everybody? David and Randy, you okay with that?
I not necessarily okay with it, but again, it's not a major issue.
It's,
I don't know why you can't cover it.
Chris would you like to speak to this. If we're gonna try and approve and order
If
something.
you're applying for multiple apartments at once, you have to pay $50 or $100 each time for background or credit check. It feels like a port tax.
A port tax.
It feels like entering into a rental agreement. Someone needs to check your credit.
If
Whether you're looking at 2 or 3 or 5, it doesn't matter. If there's a credit analysis required for the rental, they're gonna get charged.
Right, and that's the choice of the property owner
Right.
to actually pull that. So I think it's really, property owners will spread that cost over the rent over the 12 months. So to charge though, just for the entry is the barrier.
And
That's just how, I hear you.
it's a sort of the cost of doing business. I mean,
We also, I mean, I feel like just a few years ago, we stopped allowing them to charge.
You cannot charge for an application.
Right,
Yeah,
right.
can't charge.
Oh,
And this is clarifying that
Yeah.
some are charging for these other.
That's on page 2.
okay,
That's on page 3.
okay. Well, anyway, I think this would be way too big to take on right now.
well, at the moment, it's proposed to be struck, and it
Yeah.
could certainly be, I mean, I think all things are fair game in the court, in the work that the court is gonna be looking at. So,
Mhm.
To be honest, if we did keep it, the notion, unless the tenant provides a
Yeah.
credit report, I would not include that.
Oh,
I would
okay.
not include that because how do I know it's a valid credit report or what is
Ah.
online, on the credit report forgery site.
I'm fine with permissive language, allowing landlords to accept a current credit report from the
Right.
landlord, but I don't want to require it because how do you know it's true? I mean, it has to be validated.
I'm totally gonna just be that way.
okay,
This is just usually its own bill.
You're gonna do that today. Or fix that later.
When we talk about
okay, so I think we're all agreed, this section is out at the moment. So, let's move to security deposits.
Madam Chair, my apologies. Do you want the entire section out or do you want?
I think the proposal in front of us, and I think I hear agreement around the table, is that we pull 3, 4, and C.
So this does say no application fee charge.
Correct.
Great. I think we're all-
I thought, like you, I thought we had already voted.
Yeah.
So not to muddy the waters here for you.
You
But
know,
feel free
they're
to
real
jump in.
Trying to do my job. The current statutory section is what's in A on the bottom of page 2. You can't charge an application fee.
Right.
Okay, that doesn't have a definition. And so my understanding from the initial sponsors here and other bills that I've worked on, the first step here was to say, okay, let's add a definition so we can be very clear what an application fee means. Is it a fee at the time that you submit the initial application? Or is it a fee subsequent to that if you're going to charge your credit report to move forward? As you all know, think about this analogous to the whole ban the box, right? You can't ask the question on the application, but then when you start to screen applicants afterward, you get to ask the question. So that's how I look at this when you're talking about whether or not the landlord's charging for a credit check. I'm not making you submit the fee when you submit the application, but I'm telling you that if I'm going to consider your application, then you're going to have to pay for a credit check. The statute is silent to this, and I'm not aware of any court that has said that charging for a credit check is somehow a violation of this section. So you had the definition, that's what the definition was being added to provide
Right,
for
because
the
we've already
clarity.
made it.
And initially, the definition included the words credit check and
Okay.
background check to make it explicitly clear that a landlord cannot charge for a credit or a background check. I'm simply raising this to say, if you remove 3, 4, and C on the next page, and you keep 2, I think you still leave open the question of whether a landlord can charge or not for a credit or a background check. And maybe that's fine, because I think that that question
So,
currently exists.
Clarifying language in a new 3 would be a landlord may not charge to just clarify
You
that.
could add it into the definition under sub
Right.
2. I'm
Okay.
not telling you that you need to. I'm simply saying that if you're removing 3, 4, and sub C on the next page, the question still remains an open question. But that's how it currently is now.
I would add
Be
a
allowing
clarifying
things
sentence.
to move forward as it is.
Or it could be as simple as the fact that a landlord could add the cost of the credit check as part of the rent, just as he adds all other things that are
Right.
part of the operation of the building to the rent in his consideration. He doesn't have to specify anything
But does that need to be called?
unless he's gonna charge extra for it.
Well, I'm also confused about the including any third party processing payment, because when I pay the city of Burlington, I always, they explicitly call out the processing payment, because otherwise you could put a check in or whatever, like. I don't know if I can vote for anything in this bill but the no trespass. Like, I'm just saying that now as we go through this, because these are huge changes to landlord tenant law, and they would all usually be an individual bill, and we have like an hour.
They wouldn't all usually be in one bill. We've done big housing bills where
We
people
have
put in a lot
not
of
done a
stuff.
big landlord tenant bill,
Right,
because
that
it's not a good.
This,
When have we done a big landlord tenant bill? 'Cause I've been doing this for,
right, we
many
have,
years.
that's the whole attempt in this bill is to get some of these things that have not been
That's not a
resolved
good
or
idea.
addressed for a long time addressed. So we're beginning to
In an
address
hour.
them.
I,
We have the morning until 11:30. I think we need to take what we need to take on this because this is an important bill.
I would strike this whole section too, including the application fee thing, because I have no, I can't change the status quo based on no testimony. I can't do it.
Well, we have delegated this. This was in Senate Judiciary. They have done the testimony on this. If you want to look at the testimony,
My
on this,
understanding
feel
is
free.
they wouldn't have touched this. Did they?
They did catch this. It's their change. Is that correct?
This left it in.
This is as it came over from that.
Okay, so I thought was underlined. It was stuff added by Senate Judiciary.
Senate Judiciary initially struck the sub 3, 4, and subsection C on
Okay.
page 3, but they left
Okay.
sub 2
I
on page 2.
apologize. I thought this is what part of their addition.
But then they added it back in because they left it for this committee to make the change, like distribute.
The to Cameron's point, if we want to keep talking about it, I'd be comfortable with making it clear that landlords have the right to charge for a credit fee or to accept a presented credit report for somebody else, but I'd be just as soon happy to strip all this.
I am gonna propose that we just look at the no trespass and move the no trespass.
I would like to
rest
finish
out.
walking through the changes that the Senate Judiciary made. So they didn't change any of this. I'm sorry. My understanding is that this was stuff. Well, they did. They re-added. Okay.
When was the last time you?
Okay.
I mean, should we have the chair of Senate Judiciary?
No, he's represented by the Legislative Council and he is fine with this bill. It voted out of his committee and he is fine with the change Chris just proposed, which we just took out.
Madam Chair.
Yes.
I believe Cameron did state that they originally had removed all this, but represented.
Yes, and then they added it
Put
back.
back in just for us to debate, but I don't think they were necessarily enthusiastic about this language. They just wanted us to have the discussion.
Right.
That's
So we
correct.
added and it appears we are striking 3, 4, and C and the question in front of us at the moment appears to be whether to strike 2 as well.
Any indication of how the bill came out of the judiciary, why vote?
Very enthusiastic.
Sorry. Okay. You all can continue to noodle on that section. I'm going to move you to security deposits, which is going to be on page 3, the bottom of page 3. So this section would put a cap on the amount that a landlord may charge for a security deposit at an amount equal to 2 months rent. And then you get to the top of page 4, which says that the landlord can charge a separate security deposit for allowing theft. There is no cap on that amount. And then the Judiciary Committee made 2 changes here that I'll point out. First, in the House version, there was language that required a landlord to provide half of the security deposit back
Oh,
to
right.
the tenant if there was a no-clause eviction. But because the changes to the no-clause eviction timelines were removed from the bill, the Judiciary Committee removed that requirement as well because it didn't work anymore because of the timelines that were built in. So that was removed. And then the Judiciary Committee also added this change in subsection G on the bottom of page 4, on the top of page 5, to make it clear that if you're putting in that a landlord cannot charge more than 2 months rent for a security deposit. There are some municipalities that have ordinances that say a landlord can only charge 1 month's rent for a security deposit. And so this change in subsection G right there on the top of page 5 is intended to allow those municipal ordinances to remain in effect.
Hey, you mean,
Yeah.
limit the,
Weird.
Yeah, so if you look at the bottom of page 4, so you look at sub G, so it's a town or municipality may adopt an ordinance, that's current statute. The ordinance may,
may,
there
shall.
well, but then look at the 3, that's just because may not limit is not how the statute should read.
Right.
If it's a requirement, it should be a shall. So then you look at the 3, the ordinance may, you get to the subdivision A on the top of page 5. So the
Look at
municipal ordinance may limit the amount that a landlord may charge to an amount less than 2 months rent.
Thanks.
Are there municipalities that currently have more stringent policies on how a security deposit is held?
I think there are.
So we're saying they can't do that anymore.
The statute currently says they can't do that. The statute says they may not.
And we're just enforcing it to be a shall now.
So I have concerns with this, but I don't know enough about the existing practices. My concern is I feel like the riskier tenants that we're trying to get their footing again, maybe the landlord, in order to accept that risk at the outset, considering that, might want to charge more for a security deposit to assuage that risk. So I don't know how common it is that landlords are asking for 3 month rent or an additional compensatory risk, but if there's somebody that's going to vouch for the person, I don't know if I want to hobble the landlord's ability to take on risk with tools like this. So this gives me pause. So if you got a riskier tenant that you're thinking about renting to, but you're still capped at just 2 months rent, but you currently maybe you could do 3 months rent just for an additional peace of mind. I don't know if I want to take away that right, but
I have the opposite concern, but would also take this section out, which is most landlords have never dreamed of charging first, last, and security. That's a huge burden. And I worry this section says that's a reasonable standard. So I don't think
No,
we
it's-
should
it
change
says
the
it's a
status
cap,
quo
that they
right
shall not charge more than 2 months rent. So, I mean,
I'm
don't know
not
what-
okay with this
is
section.
current law that they can charge. What is current law is they can charge whatever they want. Right.
So I would need a long debate on the opposite side, which is I wouldn't want them to charge more than maybe personally, a security deposit is usually equivalent to 1 month's rent. And then you could charge a pet fee or whatever on top of that. But
Okay, so we're getting rid of the pet fee.
I wouldn't ever go to 2 months as a standard.
So
I just wouldn't touch this until we have a long debate about,
We don't have time for a long debate. We're at the
then I
end of
take the
session.
section out.
So, Chris, landlord, you're a landlord. Peter, you represent landlords. I mean, and Angela Zakowski may or may not be listening. Landlords in the room. What, do we have a notion of what on average landlords, what do you require for a security deposit?
Just a month. And I think some communities, like Burlington, maybe Brattleboro, it's limited at a month. I don't know what the common practice is, but I can't imagine people are charging more than 2 months for security.
Right.
I mean, it's commonly said, you know, people think of first and last month. Last month is this.
Right. Peter,
Great. Hi, good morning. Peter Tucker for the Vermont Association of Realtors, who have many landlords in our membership.
that's what I'm at.
You know, so when Brian Armstrong testified in House General, you know, he said, look, I generally charge 1 or 2 months depending on needs. So 2 months was sufficient.
So 2 months would cover the risk,
But
I
for
think.
you, because we've been using different terms right now. He would charge a 1 month equivalent security deposit and then ask for another 2 months in some cases. He would ask for the
No,
equivalent of 3 months.
No, I
So
didn't.
this is bigger than what he said he would ask for.
It was that was comfortable, you
2
know.
months max.
Yeah.
David has a thought.
Madam Chair, but I worry that you're confusing the conversation more. No one has said that they generally charge 3 months, a 1 month equivalent security deposit and 2 additional months.
That's not what we're talking about.
That is what is in this language.
We're talking about 2 months. Oh,
We're talking about 2 months plus a 1 month security deposit.
that's not what I see. If that,
We don't even know what we're talking about, so I suggest
No, no,
we take
our-
the section out.
no, Cameron's gonna clarify it.
The language allows for a 2-month security deposit. It gets confusing because it also clarifies that that is on top of the first month's rent. So it could be when you enter the dwelling unit, you have to come up with 3 months total. The first month's rent is the first month's rent. That's what you have to pay regardless in any situation. So this is saying you can charge 2 months for a security deposit. To the senator's point, it becomes 3 months at the point of
Right.
entry because you're paying the first month's rent. Yes.
Which is a huge national debate, and I would never want people to start setting that standard via
Right.
statute.
David,
David Mickenberg here on behalf of the city of Burlington. This was a request for the city of Burlington to make sure that our ordinance, which allows only 1 month, can continue in light of the language. So that was just a clarification. Appreciate that 2 months is the standard for the state. We said, well, Burlington is more protective. Provided 1 month. We have an ordinance in place that's been in place for years. And so we asked just for flexibility for municipalities to be more protective.
What this is, instead of saying last month's rent, what we should see this as is you're asked to pay your first month's rent when you come in, and then you could be asked to pay double the first month's rent as a security deposit. That is a huge jump from what most people are.
because that ends up
requiring.
being 3 months. I appreciate that. To balance the risk that Thomas talks about, if people are already charging 1 month security deposit for the first month's rent, would we consider limiting this to 1 additional month so that the total would be 2?
That would be the opposite of what I was speaking to, but my concern is somewhat allayed by Peter Tucker's testimony, so the 2 months.
So your concern is you're okay with this?
But Senator Hinsdale, who knows this field a lot better, is concerned with setting a standard that maybe this might send a market signal that landlords should start asking for a total of 3 months before they rent somewhere, and you're concerned about that.
Randy, David?
Yeah.
I see it as an upper boundary, not necessarily a standard practice. So, upper boundary of 2 months security deposit plus first month's rent.
But I think the upper boundary in state statute influences the market.
I agree, but the Senator Chibnall's point, if you have a high risk tenant, the ability, if you limit that to 1 month's security deposit plus the first month's rent.
Right.
2 different topics.
I would say it's just not a good practice to say, oh, their credit score is low, they're a risk. I'm going to charge them more money. You might say, I'm going to ask for a cosigner, et cetera. But this is such a bad idea. I am not voting for this bill with any of this.
Jean,
So for Jean Murray from Vermont Legal Aid, for hard to house tenants, this is a real barrier. I agree with Senator Hinsdale that it makes it very hard for people to get into apartments. So the tenancies that I see, and I see quite a few tenancies at the stage of eviction, most of the security deposits are 1 month rent. And so the other thing to think about is people who are being helped by agencies, and the agencies are being funded by the legislature to help people get into housing. The cost of establishing 3 months rent up front, it's very circular. We're paying for it. We're making it harder for people to find housing, and it's being paid for by funding to the agencies that are trying to help people get into housing. So
Thank you. No, I appreciate it. Cameron, help, just remind me, was the 2 months additional added by judiciary or was that in the original bill?
This is how it came up.
This is how it came over. So I appreciate the discussion. Let's put a pin on this as another one of the ones we have to land. I hear that we have to balance it from Thomas's risk concern to Keisha's concern. And we may want to look at 1 month or less, maybe 2 months is more.
I'm gonna say we take this section.
Let's put a pin in it.
Ask me a quick question.
Yes, Grant.
In your experience, is the 1 month security deposit, in other words, first month's rent, 1 month security deposit, more or less a standard among the landlord communities?
I think that many landlords do, only ask for 1 month security. I think that in a riskier situation that, landlords ought to have a little bit of flexibility in terms of the security that they're looking for.
Well, a lot of that security though, is also provided by a cosigner.
Could be, yeah, sure.
Can I say something? This would normally be weeks, if not months of testimony. Madam Chair, from asking who put this in and when and how, I'm very concerned. I mean, with other bills, we've said we don't have time to delve into 1 or 2 issues. I'm telling you now, like,
I appreciate that this is a challenge for you and let's come back to it. Let's just.
But no one's
this is-
quarterback this bill. Nobody even knows where the language has come from today.
Yes,
Here,
we
if
do.
that
This is the bill from the House with changes from Senate Judiciary.
But you're
That's
not
what it
sure
is.
what those changes are. really.
They're underlined. It's unclear. It's as we go through, Cameron is clarifying that for us.
I'm gonna propose once again, we go with the no trespass. There's probably. a
Fine,
couple other
you
things
can
people
propose that,
want.
but first, we're gonna go through the whole bill. Thank you.
Okay, we're on page 5, next section, retaliatory conduct prohibited. This remains the same as it came over from the House. This is a section that says that a landlord cannot retaliate against a tenant by either changing the terms of the agreement or bringing or threatening to bring an action against the tenant if the tenant, these are the provisions that the tenant, is protected from making a complaint to a government agency about health regulations, complaining to the landlord about violations, organizing as a tenant union. And then here on the top of page 6, there's 2 additions here. If the tenant takes any legal action authorized by law against the landlord, or if the tenant has contacted law enforcement to respond to an instance of domestic abuse. Adding those 2 to the list of protection for the tenant against retaliation.
Okay, I have a question.
Yeah.
We have a situation in which the tenant has done 1 or more of the things, 1, 2, or 3. Would you prohibit, according to this, the landlord from bringing an action against the tenant for something else?
No. I mean,
It's
It
done
would
in
seem
prohibit.
to discourage, this seems to give a tenant unusual protection that if they have done bad things, all they have to do to get away with it is to complain to a government agency about something else that this tenant has done.
Right.
And both may be valid.
Right. So I don't see the section as prohibiting the landlord from moving forward for any other, justifiable reason. So for example, if the tenant makes a complaint about a habitability issue and the landlord is moving forward with a termination because you're not paying rent, I wouldn't see this as the tenant having protection or being able to claim a retaliation if the landlord has another justifiable reason for why they're taking action. So similarly, if the landlord is moving forward for some other lawful reason, then they would be able to articulate that. And a court ultimately is going to be the arbiter of whether something is retaliatory in this section.
I see that as judiciary's call, I guess, like I would hope they took a lot of testimony on.
I didn't really look at this.
Okay.
Because this is our sections.
I mean, it's about legal retaliation, it's about court fees.
It's not their section. So it's up to us to make a decision on this. I think this, I support this because it further expands how they cannot be, how a tenant cannot be retaliated against. I would think we would support this. I think the landlord can move on anything else that they are, as long as they have more than one of these things in place, have reasons for eviction. So I am not.
Did they put in a study for landlord tenant court? Or are we?
Yeah, yeah.
So I'm just saying that in advance, I would leave a lot of these provisions that have some gray area to a landlord.
I don't think this has a lot of gray area. This is pretty straightforward. But I think some of the other issues we've talked about, we
I
could
guess I'm
conceivably
okay
have.
with the section, but we have not taken any testimony and neither did you.
We have been taking testimony, and we have walked through this whole bill. And we have taken testimony on a lot of it.
So
Yeah.
how common is it that a tenant would sue their landlord? And then if this happened right now without this protection, that landlord would say, you know what, I don't want you to live here anymore. We need to end this. Is this common?
Chris, Jean,
Yeah.
Peter,
I would defer to.
Chris, Peter, Jean, you want to start?
Well, landlords have premises liability, so if they have done something negligent, like neglected to repair the stairs or something, certainly there could be an action against the landlord. Like to
And this doesn't
mostly
prohibit that
to get at the landlord's premises insurance to
to fix.
compensate somebody who got injured because they never, just like a slip and fall in the department. So it's possible.
But in terms of retaliation, this is about,
When that happens, is it often that the landlord tries to retaliate? Is there examples that are motivating this language?
That's what
Is this
this
the
section-
problem we're solving?
Sure, that does happen.
And that's also covered under the first three sections. That's
Chris,
You're right.
Chris on the
mental
retaliation.
health regulation. That's an automatic.
We would never retaliate against a tenant for taking any of these actions.
As I've established previously, I'm not necessarily worried about you, I'm worried about other landlords. I think your organization.
I can't speak to it.
Okay, let's keep going.
So we'll move to the next section, which is regarding termination notice. So this is going to be on the bottom of page 6. As I mentioned, all of the changes to the termination notice period were removed from the bill, but there were a few provisions that were kept by judiciary. So
So judiciary made choices about this.
yes, ma'am. So when you're looking at the bottom of page 6, moving to the top of page 7, there were 2 provisions in this section, and in particular under subsection B, to provide protections to tenants. So if you remember, we talked about what is now subdivision 3, which says that a landlord cannot terminate the rental agreement under this subsection. Subsection B is for termination of breach of the rental agreement terms, or for breach because of criminal activity, illegal drug activity, or acts of violence.
Right, this is
So-
this the Good Samaritan
Yes,
provision?
yes.
So these are the sections, the Good Samaritan provisions, which they,
Subdivision 3 is this, what people have referred to as this Good Samaritan provision. So a landlord cannot terminate because a person is seeking medical assistance for a drug overdose, is the subject of a good faith medical request for a drug overdose, or is at the scene of a drug overdose. And then separately under 4 is the authorization of bifurcation of rental agreements for individuals who are the victims of domestic abuse, sexual assault, or stalking. So 4 says you can't terminate the rental agreement because the protected tenants, you can't terminate the rental agreement of a protected tenant because of an instance of one of those. And then you have to bifurcate the rental agreement as authorized in section 447.
which protects
So
tenants going through this challenge. And if you're in a domestic violence situation, you can bifurcate the lease so that the protected person who's being abused, can stay.
And very quickly on the next section, section 1A, this is where the new section is being added in regarding bifurcation. And there's some language change here, but what
Before we move on.
Yeah.
I have a little trouble with the, page 6, line 18, 19, 20. If a landlord has a tenant who's experiencing drug overdoses and the landlord is trying to move the tenant out, evict them, this seems to cause that to pause. If that's not grounds for objection or what have you, but it certainly is an indicator of tenant risk. That if there is a pattern of drug overdose, this seems to completely put everything in favor of the person who's experiencing the overdoses, tenant. I'm sure I'm comfortable with that. Because if the landlord sees that he's got a tenant, drug overdose 1, repeated patterns, whether they're trying to get, they're seeking help for their condition. I think this is out of balance between the landlord and the tenant's rights. And I paused on this way back when we first went over this back in February, and I still hold that same reservation.
So, so for you, so you may have somebody who has a substance abuse disorder who pays the rent, who has a good job, who is actually paying rent and being a good tenant. So in one circumstance, this is saying you
We're talking about
can't,
drug overdose.
right,
We're not talking
there
about-
might be, right. I think your concern is repeated drug overdose. Is that what I'm hearing you say? And I don't know if they're paying the rent, if they're paying rent on time.
Sure.
It's, you know, that's a tough one.
I don't care if they're paying the rent. You've got, say, a multi-tenant dwelling, you've got drug overdoses one time, multiple times. It's an indicator of future risk. Landlord should have the opportunity to take that. So
That's what I think you were saying, and I agree landlords should have some rights in these cases. I also agree that some municipalities should have some authority. Cameron, would this, for example, the city of Burlington be able to enact this type of restriction if they so desire in the current construct without us putting it into state statute? No.
I had a different suggestion. What I actually think we need to, like, infringing on the private enjoyment of the premises of a tenant is a very serious matter for landlords. So if we go, like, we shouldn't gloss over we should have weeks of testimony on the retaliatory conduct section, because if people want to go back to page 5, lines 10 through 13, a landlord may not retaliate by establishing or changing the terms of a rental agreement or by bringing or threatening to bring an action against a tenant landlords should take that very seriously when they're talking about then the next items in this section. You know, we've debated 1 through 3 very heavily in past years. The 4 and 5 are pretty complex and messy. If you have a domestic violence situation and somebody kicks in a door and the landlord says that's part of your security deposit and the tenant says, no, it was domestic violence. This actually makes things pretty unclear and imbalanced without taking any testimony. And then you're saying, okay, you also don't have the right to terminate the lease. I think termination of a lease is a very final and serious matter, and we should put more language in here about, you can't terminate a lease because of the chaos of criminal activity that the person might be a victim of. And I would add the termination, the Good Samaritan section, accommodation for a disability, if it's not in the underlying language. But we're making it really, I don't think people are appreciating how much all of these sections affect each other. At all, basically. Like, I think this is like a very
So
untethered pursuit of changes to the
on the
landlord
good,
tenant law.
on the good, so,
I'm in favor
on
of the
the
Good
good-
Samaritan piece, but you can't leave the retaliatory conduct section alone. I mean, you can't add to that of the same things you're talking about in the termination of lease. You're like, you're
what
really
we're saying
putting
in
people
one
in a bind
is you
here.
cannot retaliate for these reasons.
You not only can you not retaliate, I need you to understand it says threaten. Any
It's not
action
taken
or take
any
any action.
legal action authorized by law against the landlord or
No,
has
go back
contacted
to
law.
page 5. A landlord may not retaliate by establishing or changing terms of rental agreement or by bringing or threatening to bring an action against a tenant. Well before a rental agreement is terminated, you would then be taking a landlord's rights away to even say to somebody, this is getting really problematic that things keep getting broken and, you know, you're doing this or that, there's drug overdoses, etc.
This is current law. The page
Go to
5 on
court.
retaliatory.
Within my,
4465.
we're changing current law on the next page with 4 and 5. And those things are very similar to what we're saying. You then can't terminate a rental agreement below. I'm asking everyone to appreciate that these two sections are highly related. If a landlord and tenant are in disputes and they're going back and forth in court about other things, or the landlord has said, this is a lot of breaches of your existing lease, you've made it very difficult for them to have that conversation with the tenant in the retaliation section, because we take very seriously what is considered retaliation. And then we're saying they also can't terminate the agreement. I'm in favor of saying they can't terminate the agreement for some of these things. It's very difficult to then say, you also can't even talk about it with the
Well, it
tenant.
doesn't say you can't talk about it. It just says you can't take
Threatening to
retaliatory
bring out.
action. David?
Just
Yeah.
agreeing, threatening to bring action.
Is a
It's
huge,
conversation. It's not a,
and landlords take that very seriously with these other provisions. It is considered kind of tenant harassment if you say like, hey, I saw a bike outside and I want to talk to you about it and this and this and this. You really have to be very careful in this section. And now you're saying you also can't talk to them if they have a legal action against you. You also can't talk to them if there might be an instance of domestic abuse that's causing a lot of damage or criminal activity on the premises. And then you also can't terminate their lease for such related things. I think it is very serious to terminate a lease without
Right.
a landlord tenant court or a judicial process around these matters. But you're saying before that, you can't even talk to them about it.
Or address it.
And this is why I would,
So
Take
this
out
is
a
why
lot.
you would strike 4 and 5.
I would much rather focus on when it's serious enough to terminate a tenancy versus not allowing them to get into the messiness of
Or retaliate. Retaliate.
of not being able to talk to them
Says
about.
what to whom, I would,
Yeah,
frankly, the whole retaliatory conduct section, I would delete.
Well, it's current law,
Nothing recorded.
except 4 and 5.
so
4 and 5
Knowing.
is added to expand.
all I'm saying is I don't think we can have a conversation about termination of tenancy without not doing something that we've taken no testimony about in what is retaliatory behavior, because landlords currently take that very seriously. It would be very hard for us to just say, oh, now you can't have these conversations or these conversations. but you also can't terminate their tenancy. So I don't know where everybody else is. I'm in favor of the Good Samaritan provision, and I might work to strengthen it if we have more time.
Right.
But I need people
But
to
you're
appreciate how unworkable it is to do all of these things at once.
I don't think it's necessarily unworkable if we try and fix it along the way. So, Cameron, so what I hear from you is maybe consider, adding to, well, I hear from David, he's not comfortable with the Good Samaritan provisions in the first place. Just because there may be reasons if repeated offense occurs that a landlord would want to be able to take action against a tenant. And I hear you wanting to maybe expand that to
Well,
include other things, but I think those are already protected. A disability is already protected in the law. I mean, there are other things that
Drug
are
abuse is
protected.
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 Is it?
I believe so.
Substance abuse disorder, then I'm
Not the attorney to answer that question.
Oh,
I don't
no, I
see that
said
as a disability.
Keisha didn't talk about that. Keisha mentioned a disability.
And I'm not saying drug use. I mean, this doesn't say drug use. It says an overdose, I mean, it's a different thing.
Right.
I think if a landlord doesn't want a tenant in their building because they are instances of substance abuse, they should have a right to determine the agreement. So I'm in the same case of Senator Weeks, so I don't like this section.
Right. Jean, did you have something you wanted to add?
You got kids downstairs, you got a rental unit upstairs.
Chris has something to add.
I could just say that right now, under current law, if you are using an illegal drug in your apartment, the landlord can move to evict you.
But what if somebody else is?
If,
Sorry, in illegal drug or legal drug.
Is it-
We
illegal.
all get that.
Really,
So right now, if there are illegal drugs being used in an apartment, either by
I think it's-
tenants, we can't deal with guests on top of that they can begin to move to evict you, which is why they're trying to do this. David, what's your thought?
Just to speak to this section, Dave, 175 Vermonters last year lost their lives to preventable overdoses. This law is modeled after a law that was almost, I think, unanimously passed in 2013, which said and has been promoted by everything from the colonel of the state police and others to say, if you're having an overdose, call for assistance. We
Right.
value your life.
But they don't want to
We
be
want
punished for calling for assistance.
either criminally, and in this case, and this is about the seeking of assistance, and it's limited to the seeking of assistance for, and so this is intended to be a life-saving measure. There hasn't been one. I sent Senator Weeks the memo when it came up that we supplied to the committee. There hasn't been any testimony against this provision, just for context. And this is about specifically the moment where you are calling to seek assistance, because studies have shown that people have a fear of eviction and therefore they won't call. If it's the risk of losing their house or surviving an overdose, many people take the risk of surviving an overdose than losing their house.
Yeah, what we're discussing is a business arrangement, not a social arrangement.
Yeah.
We've got a landlord. We're not talking necessarily about, our large housers, which we subsidize. We're talking about mom and pop with a couple of units. Put yourself in that scenario. You've got drug overdoses. Okay, I get it. There's a certain aspect of, we ought to be conscious of that. But if we've got a repeated behavior of drug overdose, or we've got a landlord who's not tolerant of drug overdoses, and that's a business arrangement.
Yeah.
That's an indicator of risk.
The last thing I'll say is, and there's other evidence of that, and I'm sure if somebody's overdosing, there probably is other evidence of that. Other evidence
that's
not
enough.
associated,
That's what this indicator.
not associated with the call. Other
Right.
evidence can be used and a termination can be brought.
But this is with the call for assistance, and I've forgotten your names.
Fine. I'm Katarina Lesiason with the Vermont Network
That's right.
Against Domestic
That's
and
right.
Sexual Violence. To speak to number 5, similar to what David shared, This is about how they've.
We're on number 3 here,
What
Good
page?
Samaritan.
Sorry, number 5 of the same, the retaliatory conduct prohibited.
Oh, we haven't done the next section, but
Yeah,
I mean, and I understand the situation. It's just.
We're talking about drug overdose. We're not talking about the next few years at the moment.
Right, it had come up, so I just wanted to say
Yeah, no,
that section
like-
is about how it's the contact to law enforcement. It's not the actual domestic violence occurring. We don't want to prevent any survivor from contacting law enforcement to
so
seek
this
justice.
is protecting the abused.
Yeah,
This is meant to protect the abused.
Yep.
Agreed.
I will say truly, like, it is true that when police or fire show up at a unit, people's reaction around them is to say, oh, like, I don't want this person living here anymore. And that's a great concern. I understand what you're saying, Katerina, but a lot of things could be considered threatening retaliation if someone has contacted law enforcement for a domestic disturbance, that then get used against that person before they're able to say, hey, what's really going on here? Because we can't keep having doors kicked in or, someone yelling in the hallway.
right, it is the act of calling law enforcement. That was the clarifying part of it.
It's just, if we read it together with the section above, this is a huge conversation. It's a huge conversation about what's considered threatening in action. That I then think is very much linked to, I'd rather focus on, you can't eject or terminate somebody's presence because of these same things. Because then we talk about, they're protected from a pattern of
Right.
domestic abuse, sexual assault, and
But also a pattern, to go to David and Tom's point, a pattern of calling for drug, for assistance with an overdose. To go to David and Tom's concern, could we address that with a reference to repeated, to more than one offense or more than 2? Because I think the call is life-saving. What we're talking about is not being punished for a life-saving measure that is taken. We do not want people living in fear of calling for help if they're afraid of being ejected. I think that I hear your concern. I also hear 175 lives that may or may not have been saved in this circumstance, but certainly some are. Could we put a cap on the number of times that could be taken? Jean?
So earlier, people were talking about, is substance abuse disorder a disability? And it is a disability. And you can get Social Security benefits for the disability. The thing is, you're not supposed to be using. You can't be an active user. That's substance abuse. It's not substance abuse disorder. But the problem with substance abuse disorder, and you should have testimony on this because certainly I'm not an expert on it, but the problem with it is people relapse. That's part of the disorder. And so if you're saying, yeah, you get one free call for medical help, but the third one you don't get, that's when the person dies. So it's very hard to have the Good Samaritan paragraph, which I support, is a really great idea, but to understand what it is you're doing without expert testimony on substance abuse disorder is probably not, I wouldn't support that.
So the Judiciary Committee did take testimony on this. They made decisions on this and included this language. So, I mean, we have had a committee already had testimony on this. And if we, you can disagree with it, but this is what Judiciary has passed out and supports. So on a 5-0 vote. So let's just keep moving because I would like.
Madam Chair, in the interest of time, since we are trying to do this, we all should just straw poll these things as we go along.
Yeah.
Just doubling back, I don't know how we're gonna do that in the next
Okay.
20, 30 minutes.
Okay.
So if you want to straw poll on this, just to close it off. Do we want to keep this section? Center weeks, have you softened in your position?
No, I have not.
Okay, so
Or-
on this section at the moment, on the Good Samaritan section, who would support keeping it in? And who would support taking it out? Okay,
I'm gonna ask maybe that I hate to single out drug overdoses, but if we don't have the protection for, and I would even say, let's say it's not a drug overdose, like, you know, you can have a tenant who has a history of substance abuse disorder, have a wellness check called by their parents because they haven't heard from them in a week. And that can spook a lot of other people that the police came and did a wellness check on that person. And so maybe we're not getting into the instance of a drug overdose, but I would still say we should make sure there's accommodation for a disability and in this section, and a pattern of protected from a pattern of domestic abuse, sexual assault, etc., and the bifurcation of the rental agreement. If I wouldn't strike this section entirely, I would say let's leave the conversation about drug overdoses for another day. It is a conversation that I think is worth having.
so that's just a straw poll. I think people's opinions hopefully can be changed with more testimony, with talking to our judiciary counterparts. And so I would,
I'm actually saying we don't have time for that, and
To your point,
I'd
I
ask
agree,
if
the
your vote-
bifurcation
yeah.
part is separate to me. So if you look
Right.
at B, I'm not against the bifurcation of the rental agreement and allowing landlords to do that. I see that as separate.
so for A and B, we're talking about.
Well, for B, I see the bifurcation part.
and I'm recommending keeping 4A.
I think 4A and 4B are important together.
And I'm suggesting adding accommodation for a disability,
So
that
I
they can bring an action.
would interpret
I
that.
don't think they can at the
Well,
moment.
just have been on 3, so.
Oh, okay.
Yeah, so maybe now you're talking about 4A.
I wanted to make sure that that's, yeah, so we
We have that on the screen,
So
so
the-
we're all on the same page.
So we have it in front of us. The proposal that I hear is that we strike that 3 of the 5 of us are interested in striking 3, but would be okay with keeping 4A and B.
True,
Yes,
true, yes.
Randy?
Yes.
and then I would ask how people feel about adding accommodation. You can't terminate a rental agreement because someone has requested accommodation for a disability.
I don't believe you can do that.
We'll let that.
I,
You gotta put in an
Cameron?
elevator.
You can't terminate a rental agreement because someone asks for an accommodation. That's not a reason in the statute that would allow you to terminate a rental agreement.
But we just don't know
Someone- what I could imagine something happening is if someone requested an accommodation and maybe they were persistent or
persistent,
Mm.
we can
leave
manage.
it out and the landlord didn't want the person to be there anymore, the landlord could just do a no cause termination. I think the person could try to bring a claim that they've been discriminated against because of their disability, but
They're
they would
protected. I mean,
have
that's a
to-
protected class.
it's gonna be a fact scenario they would have to prove in court.
Right. But they would have to do that now, even as a protected class.
Correct.
Right.
Can't discriminate against people because of a disability.
That's already included in it.
Well, I guess I would say it's then what is the harm in spelling it out here?
I think it's already in law, so I don't.
But I think it would probably be more proper to be in the section about retaliation. You can't change the terms or
For
have to bring
for
an
a
action
request.
against somebody who
Yeah.
makes a request for an accommodation.
I would-
due to a disability.
I think that's a good,
Okay,
yeah.
that I don't know what people feel about that. I would like to put in some underscoring language about protecting.
Right. So a request for a request for accommodation.
In the retaliation.
Not quite sure what
Accommodation mean,
If,
How far does it go?
Build a ramp for a wheelchair.
It does go as far as
In terms of, does it require a landlord to do capital construction because a person has a disability?
it's just the
And
request.
how far does that go?
well, they would probably know at the time, so if they had the disability at the time that they entered into the rental agreement, then the landlord does have the right to say that's too much of a hardship to put a ramp in this historic building or an elevator in this historic building.
Well, they wouldn't then probably take the apartment if they couldn't.
Right,
get-
that's
Well,
not a
presumably,
discriminatory.
That there would be a requirement for the potential tenant to disclose that or the contract is signed.
Cameron has something to add to this.
Real quick, I was gonna say, I just wanted to double check. I think this is already covered. This is in the unfair housing practices section.
Right.
And
Right.
it says that individual cannot refuse to make reasonable accommodations in rules, policies, practices, or services when
Right.
such accommodation may be necessary. Now, that's about rules, policies, practices, services, but
And that's not, this would be belts and suspenders essentially,
Yeah, but
That-
I'm not saying don't, I'm not saying you
because it's,
but it's there already.
it's there in fair housing. Fair housing,
But this
You
will
know.
all be incorporated into landlord tenant law, David.
Yeah, we kind of migrated into this conversation with the overdose question, substance use disorder being equated to disability, being equated to protected class. That's where I trip up on the whole issue. And again, we're going, I fully recognize that if there's a tenant and there's a wheelchair involved, this question of does the landlord have to accommodate at the start of the contract? Probably not. In the middle of the contract where there's an accident or what have you, well, maybe not. And that's putting an elevator or ramp to your point in historic. That's a whole different question. But I do not want to migrate off the question of substance use disorder being equated with disability, being equated with protected class in the context of a landlord tenant relationship. I don't see that. I don't see that thread all the way through. And I could be wrong legally, but I think it's too much for a landlord to take on.
okay, there are people in recovery who do get discriminated against, though. And the question is that a protected accommodation that you not say there's people checking on you too much?
Jean and Cameron are probably, and Chris, do you have anything to add on this? Because I do believe they are protected. Yeah, Jean.
So in fair housing law, which Vermont has, there's a difference between a reasonable accommodation and a reasonable modification. Modification means the ramp, the grab bars, whatever. And if the landlord receives federal funding, the landlord might have to pay for that. But a reasonable accommodation is simply a change in practices, rules, or procedures, and it's not meant in the defense. I guess if you're a landlord and you don't want to provide an accommodation, you say this alters my business. So the idea of a reasonable accommodation is where a person with a disability has run up against a problem that seems incompatible with being a tenant. You ask for accommodation saying, if I only had my worker come see me once a week, or if I only had this, then I would be able to conform to what is expected of tenants. It is not ever asking landlords to say you have to put up with, I don't know, somebody banging on the walls because that's part of their disability. There's a way to accommodate that, which is different than ramps and grab bars and expensive things that landlords if somebody says, I want your apartment, and in order to have it, I have to put a ramp in, the landlord should be able to say, fine, but you have to pay for it.
Right. They're able to do that now.
That would be the law now.
Right. Right. So in terms of substance abuse, because I think David and Tom's focus is particularly on substance abuse.
Well, it is a disability. It doesn't mean that people have to put up with what people think of as what goes along with the disability, like a drunk person shouting all the time. They don't have to put up with that behavior. But you can't discriminate against a person simply because they're in recovery.
So,
That you might think being in recovery is a risk. But you might think having somebody with a wheelchair is a risk in your building. You might think that having somebody.
life is a risk. I mean, it's all risk. We all present risk at various points in our lives. I think that with, substance abuse itself is disorder, is a disability. I think that what we have to, so at the moment, we have a struggle to take it out. I'd really like to continue. I think we have a struggle to take it out. I think that the fair housing practices cover retaliation of a person with a disability. We're requesting an accommodation. We are, at the moment, my understanding is we're keeping 4A and B on top of page 7. And let's move on to the right to bifurcate of a rental agreement.
Okay. This is page 7, the next section, section 1A. The Judiciary Committee made some minor tweaks to the language in this section. Ultimately, what it does is it allows a protected tenant to request bifurcation of a rental agreement due to an instance of domestic abuse, sexual assault, or stalking, and the landlord may agree to that bifurcation. That's in the sub 1A. In the sub 2, if the protected tenant includes with the written request, and my apologies, I should have indicated there, it has to be a written request, can't be verbal. If the protected tenant includes with the written request a court order that requires the perpetrator to leave the premises, so we're talking about another tenant or another lawful occupant of that dwelling unit, if the court order requires that person to leave, then the landlord is obligated to bifurcate the rental agreement at that. So it's not a may, it's a shall. Submit the written request, no court order, landlord may bifurcate. You submit the written request, there is a court order, the landlord must bifurcate in that instance.
This section I find.
And then just very quickly, there was the remainder of this was about the sub 3 is new language that would prohibit a landlord from requiring some sort of written documentation or written support as part of the request. And then the sub B is about giving the person the reasonable opportunity to seek additional tenants if someone is removed from the unit, or to have additional opportunities to find new housing. That is the same as in other times.
Surprised we need to authorize this. It seems like just something reasonable that they could be able to do, but.
Yeah, why doesn't it need to be in statute? It's just a.
It's a requirement in some instances. So if the written, as I mentioned in the 2, if the written request is being submitted with that court order, then the landlord would be obligated to do this at this point.
Well, so a lot. The most common sort of criminal disputes we see, which is why we need a landlord tenant court, are domestic disputes, right? And so just kind of bring up all the things that you could see, especially from my experience doing domestic violence work. The question then becomes, is that landlord then able to recoup costs from damage, et cetera, from both parties, or I mean, really, then the tenant has to take responsibility that they are also on the hook for the higher security deposit, on the hook. Like, there's consequences to being the final person on the rental agreement. And so that's why you probably have to say that there's sort of a process for this, just because that tenant should understand that they are then responsible for everything in the rental agreement. And this is good for them.
It's a good point. I agree, but I'm curious what the advocates say about that bifurcation. If that is in fact the case, that the remaining tenant absorbs all the terms of the original contract.
Chris or Gene? Or Katerina?
We operate by similar rules right now.
Katerina.
It's current, so this language came from VAWA, the Violence Against Women Act,
Yes.
public housing authorities people who receive public housing vouchers already do this. So this would be expanding it to private landlords, or the option of it to private
Right.
landlords as well.
So I would support this section.
I'm just saying, I brought this up for the advocates earlier. I mean, in 2015, you know, I wrote a bill saying you have to put everyone on the rental agreement. This is before I met my husband. In fact, we were in the same article in the Burlington Free Press without ever having met. You have to put in the rental agreement all the parties that are living in the unit. That's not a current requirement of law, that tenants have to take the responsibility to say who is living in the apartment. So there's a lot of points at which the only tenant that's on the agreement might be trying to say, this is not my fault, this is not my responsibility.
So
They
what,
are still held accountable to that, but it's very hard when we don't require people's names on rental agreements in the first place.
so that is a challenge if you're then. gonna
It's a
fight for
huge
tenant.
challenge. It was on the cover of the Free Press 10 years ago.
Right, okay, so why haven't we fixed that here? And could we fix it by really requiring that all tenants be required to be listed on the lease?
I don't know what
We
problem.
could do that.
And this also relates to the definition of a long-term rental as 30 days.
We're not doing that here, but, that's in front of other committees. Yes, oh, Peter, just make noise,
Oh,
you know, we can't, yes.
So Peter Tucker for the Vermont Association of Realtors, you know, I think that in practice, you know, there is a, you know, like 1-page document that a tenant can produce to say, you know, I'd like you to buy the rental agreement. But in terms of, you know, a landlord needing to be able to allow at least 90 days for that tenant to not pay rent or pay partial rent. You know, this is on page 8, line 14. You know, seems that puts an undue burden on the landlord.
Yeah, I agree with that. I didn't read about it. So we would agree.
You missed why this section is maybe articulated and also, you know, it's a big impact.
So sorry, I have two suggestions here. That I'm hearing. One is that we actually should require all tenants in a space to be on the lease agreement, so that when you bifurcate it, they're actually all tenants are on the lease. I think that's what I hear Keisha suggesting. And Peter is the landlord concern is on line 8, did you say?
Yeah, 9 to 14.
No, 9 to 14. And what's your concern here again, sir?
That you're asking the landlord to you know, take financial responsibility for the inability of the remaining tenants to pay the rent. Reasonable opportunity to find another tenant or find another roommate for, you know, shall be no less than 90 days. You know, that's 3 months of maybe partial rent being paid. So.
Got it. So that we're exposing the landlord to losing rent here. Is that what you're saying?
We're exposing them to a lot in terms of how they negotiate with the remaining tenant about what constitutes the rental agreement and who's responsible for anything that happened during that time period. Plus, if someone just stops paying rent, what
And
happens?
we also at the moment still have $1 million in the budget for our rental, both rental arrears and fixing apartments, with the concern that we've addressed in the past, where people are punished for physical damage to the apartment if their abusive spouse has done that, and they have an opportunity to fix it and help get some support for that.
That's been removed from the, as far as,
No.
it's maybe in the budget, but it's not in the bill.
It's in the budget.
Right, but it's not in the bill.
No, it's not in the bill. It's in the
It
budget.
was,
That's why I'm mentioning it. So we know that that's there for So
My point is that we didn't have an opportunity to object to that either. It's just in the budget.
right,
It was in the bill, it's stripped out of the bill, not an.
it was in the
opportunity.
House bill and it was
Correct.
taken out and put in the budget there.
So
So
right, I understand all that. I just wish that it's, in this environment, we could have a conversation about those kinds of programs. That's all I'm saying.
Right.
But it's in the budget.
and we
So have to
have
swallow.
in the past, and actually this committee put that money in several years ago to cure.
I
when you
understand the
would-
purpose of it, but
Yeah.
I don't have to agree with it.
Yeah,
As,
no, no.
as far as the use of stage rate.
So we
That's what I'm
have-
saying.
We have something we can fix right now in front of us. So I think, I hear you suggesting that we require all tenants on a lease, in an apartment to be on a lease. That's one, yes.
I guess what I'm saying is, I'm not trying to, choose a side here that this is a very common and complicated area of the law. This happens a lot, that there's a dispute between two intimate partners and there's a lot of messiness after that.
Right.
The question is, does this resolve the messiness, or is this us making more problems?
I don't think anything we could do can resolve the messiness of some of those.
The
situations,
landlord
but-
tenant court.
But and we're looking at that, and there is a whole study. I mean, we've done that. We've worked on that. That was a priority for both of our committees.
I'm trying to give my colleagues enough information to understand why this section might be more complicated than.
Do you want to strip it?
No, I don't want to strip this section necessarily. The judiciary worked on this, and
I would tie it more to the no trespass or whatever we're trying to do to solve the
so it,
problem of someone who's unwelcome in the building or the apartment.
well, let's get to that in this action though. I mean, I
This
think
just has more consequences than
so.
anyone is appreciating right now.
Maybe
I just see it as permissive language. But maybe I'm not seeing it right.
I agree. I think that we also, I don't know how we fix the exposing landlords to lost rent here unless there is an opportunity. I mean, so there is an opportunity through this fund to maybe collect some of that. I guess my question is,
What
is there anything in here where we can reduce the landlord's risk in losing
It's-
partial rent for 3 months?
Right.
Strip the paragraph B1
B1, just
one.
and 2, subsection. Line 9 through 15.
Katerina.
I would just want to share with the committee that B1 is allowing that tenant to not immediately feel as if they were evicted, right? Because if they choose to bifurcate and then they can't pay for their unit because of life circumstances, it means that they wouldn't have a roof over their heads through no fault of their own. So to me, that's what B1 says. 2 is the length of time that they could be there. So
how would you protect the landlord? I
Yeah,
appreciate this is protecting the tenant, and we appreciate the tenants in these circumstances.
Mhm.
It is brutal.
Yeah.
I mean, there's no question. The question is that, that's true for the tenant. How do we also protect the landlord from not being financially injured as the other party? Have more people injured is not good.
Yeah.
So, we have one person or maybe a whole family of injured people trying to recover and trying to figure out how to pay for the apartment. I appreciate giving them an opportunity to figure that out. How do we protect the landlord during that? And I think that's the question.
That is interesting.
Thank you. So I think let's put a pin in that and keep going. Because now we're moving into the agenda. And I'm gonna give this till 10:15, and then we're gonna turn to the other 2 housing bills, which I hope we can get out. So this clearly we're not gonna be able to get out today, and we're gonna need some more time. I appreciate that. I want to hear from all of you before the end of the day if possible, because Kiara and I have to put an A on we have an hour and a half each day except Monday.
I just raised the previous point that putting a pin in it, I don't know when we're gonna come back to it. So
We're
if you
coming
just-
back. No. We need suggestions on You mean you're just suggesting striking B1?
Yeah, I mean, just where we are in this, if we just do the straw polls, that moves us along to get us to a vote, if that's what you're after.
I appreciate that. I think that's there may or may not be a
Also,
fix
if the
here.
bill just never comes out and it just dies on the wall, that's also an option.
No, I don't think that's an option. I think that's a poor
But
option.
if you don't-
Judiciary did a lot of work on
And
it.
I think you should do straw polls, and then that way we get it.
Okay.
to a vote, but
So
that's just me.
we straw poll the last section, let's straw poll, pulling B1 until we have how a straw poll on requiring that all tenants be on the lease.
So
Yeah.
I interject right now and say that's extremely problematic from a drafting perspective.
Okay.
I'm sorry, I was bringing it up more as a,
Okay,
it's always more complicated landlord tenant.
Yeah,
law is
no, I
extremely
appreciate it.
Complicated, and we shouldn't be
Appreciate
doing it in an hour.
appreciate it. We're not trying to do it in an hour. Thank you. I was hoping we would be supportive of what the judiciary did and move it along, but we're
We could
clearly-
do that.
I know. Let's
That would be the no trespass.
yeah, we're getting to the business. Appreciate that. Okay, so the other option at the moment then, without that, is striking section B1 until we can come up with a fix for how the landlords are kept whole.
B1 and 2.
B1 and 2, or yes. And I hear Katharina, and it is, we need to figure out how we can help protect our tenants who are going through this. But until we can figure out how to balance Gail.
Gail's that's on behalf of the network. I don't know if your straw poll means you're closing out this section, but
It means
we would like the opportunity to consider your concerns and for that. So
we don't have a lot of time. We have next week. That's it. So on an hour and a half each day, unless people are willing to work through it. So Katerina has, I think, been very articulate about why that's important for us to keep. I don't think we need to hear much more testimony on, but I think I hear my committee. So the straw poll at the moment on keeping sections B1 and 2, those who support keeping it in. I support keeping it in. Those who are,
Sorry.
we're doing a straw poll on B1 and 2.
I'd be happy to look at new language, I guess, or I don't think we should do both.
B1 and 2, I will ask again. That is the request to have a straw poll on B1 and 2. And that this is the 90-day leniency, 90-day period to allow a tenant who's been the subject of domestic violence to allow themselves to find a way to satisfy the rental requirement.
On discussion of that quasi motion, I support striking this now, but I welcome alternative language.
Sure.
Okay.
Conversation.
Great.
It's just running out of runway.
Yeah.
You know,
Okay.
That's right.
It's only so many moments, this minutes.
So who is supportive of striking it now with further proposal of amendment?
I support striking it now, and then if you want to have more conversation.
Okay.
Between now and we vote this.
Here's fine.
Who supports striking it now? Great, okay. And two of us would keep it in, I think. Okay. And I think that's a charge to our advocates. If you can come up with new language that the request is really to figure out a way to keep the landlord whole as a tenant goes through this. No, quite frankly. Okay, we will look for new language. Okay, going to ejectment.
We're on page 8. Moving to the top of page 9, this is the changes in the ejectment chapter. As I mentioned earlier, the Judiciary Committee has removed all of the language regarding a new subchapter for ejectment, including the expedited hearings that are built within that subchapter. So a few changes that remain. The first here on page 9 is just a technical amendment to this section for payment of rent to court, the rent escrow process. There are 2 subsection A's. We're removing one of them. Now we get to the next section, which is about property of the tenant remaining on the premises after eviction. So if you all remember when we did our walkthrough, I discussed the fact that You go through the ejectment process, the landlord receives the writ of possession. That writ of possession has to be served on the tenant, the defendant. And then at a point later in time, the sheriff would then come back and remove that individual from the premises if they remain. That time frame as to when it's served and when the sheriff comes back is different depending on why the writ of possession was issued under what statutory section. It could be 5 days, it could be 7 days, it could be 14 days. Current statute says that the landlord has to maintain the property for at least 15 days after service of the writ. What this amendment is doing is taking that out and saying that the landlord can dispose of the property immediately upon being restored to possession. So
Immediately after the ejection process is completed.
immediately after the sheriff has come back and removed the individual from the property. So again, that could be as short as 6 days, could be as short as 8 days, could be as short as.
It's a few days. It's not like that second.
Yes, I'm just pointing out the fact that you're reducing it potentially from 15 all the way down to 6 in some instances. So that's my,
Okay.
it's a succinct way of articulating this.
Yes, thank you, Thomas.
This is the putting the stuff to the curb. So essentially,
The 6
they have
days.
no obligation to put it under any climate controlled environment and storage. They can just toss it to the curb right after the person's ejected.
Well, they have 6 or 8 days to
Yes.
move everything.
So
Chris,
I have concerns with this.
okay, Chris.
I was just gonna say that, if the ejectment is on a shorter time frame, the writ is served, we get possession after 5 days. Then we would, in the current law, then we have to take the belongings and store it for 10 days someplace. And so we can.
More cost to the landlord.
And so there's a cost. And, then
There are costs when you go in business and.
No, but there are also responsibilities of being a tenant. I mean, I'm sorry, it's also responsibility to.
No, but
your
we,
stuff.
I mean, we have very significant laws about storing rentals property. You're saying that there are other laws that guide the safe storage so that reasonably they can get their stuff without it being damaged.
Under the current law, there's, as Council just explained, there's 3 different timeframes.
Mm-hmm.
And the storage of, or allowing for access to possessions has 1 timeframe.
So we're shortening that time frame.
So we're only shortening the timeframe for the period where the possession is shortened, but not for the period that's. So one of the possession periods is 14 days.
What, can we talk?
That's
about
14 days when they
current
could go get their stuff.
Right.
And we're shortening that to immediately.
So
No.
Shortening that to 5 days. Maybe I'll let council.
Yeah, let me jump back.
Back, you go
Let me
back,
jump back.
go for it.
At the end of the ejectment action, so you've got the termination, you've got the ejectment. Court
Court has agreed,
says,
you're all set.
landlord plaintiff, you have the writ of possession. That has to be served by the sheriff. And then the sheriff, in each of the statutory sections, it says it's served by the sheriff. And then after a period of time, the sheriff has to come back and physically remove the person from the property if they
haven't already.
Yes, sir. Yes. Sir. The timeframes are 5, 7, or 14 days. The court could order it longer, but statutory timeframes are 5, 7, or 14 days. What this section is dealing with here is saying after the ejectment for the eviction, what does the landlord have to do with the property? And how long does the landlord have to keep that person's property before they can dispose of it? Put it to the garbage, if you will, throw it away. And the statute currently says that the landlord has to keep the property for 15 days after the service of the writ. And so,
That's current law.
yes, ma'am.
Okay.
But so that's the initial.
scenario. So one scenario is, let's take the 5-day scenario. The writ is served. The landlord comes back 5 days later and physically removes the person. the landlord has to then maintain that property for another 10 days. At least.
I like that.
Okay, now let's take the 14-day time frame. Sheriff serves, comes back 14 days later, executes, removes the individual from the property. If the 15 days haven't passed, the landlord has to keep it for one more day. Then at that point can dispose of it. What this amendment is doing is it's saying immediately upon the landlord being restored to possession. So it's going to be either the 5-day window, the 7-day window, or the 14-day window. Immediately upon being restored to possession, you can dispose. So it impacts those shorter timeframes. Because if it's the 5-day window, you have to keep it for another 10 days. If it's the 7-day window, you have to keep it for another 8 days. In those situations, if this amendment moves forward, they don't have to maintain the property for that additional 10 days or the additional 8 days.
This is extremely confusing and we should talk to sheriffs. Sheriffs already have a hard enough time with evictions are hard to do. Ejectments, evictions, whatever we want to call them, they're very hard to do. They're very hard on our
This isn't-
sheriff.
Yeah, but this isn't really the sheriff's job.
This-
This is the
I don't even
landlord, what they do
understand
with
what
all
the time frame is. I think we need a very
People trying to
consistent
get
time
this
frame.
So I believe
So-
against this and if, because
So right now, people have quite a long time to get their stuff out.
But
And again, if you're concerned about landlords losing money,
I'm
this is
concerned about the
losing
tenants
almost the
too.
whole month.
The
right?
landlords take on a risk when they have somebody live in their home and there's costs to that business. One of the costs means they maintain their stuff for a period of time.
and they have storage, whereas sheriffs and police often have lawsuits against them for damaging something or
Dave,
not storing it properly.
Okay,
So I just want to reflect on the fact that the eviction notice has been served. Really, the question is how much longer does the landlord have to tolerate the tenant before eviction? That's set in stone. Question is, how much time is there for them to get their personal possessions out of the apartment? And why isn't it congruent with the person themselves leaving? They've already been notified that they're going to go.
well, they've already been
lost
to
legal
They
reject.
got kids, they gotta drive
And also,
somewhere.
be-
they
so-
gotta do
But
things.
remember, this is an eviction.
They've
There's
been
something
in
that's gone
process
very
for
wrong.
this
Well, it's
already.
not an eviction, it's an ejectment, and the problem is
So
eviction,
they-
no, it's not.
But
No,
you
it
just
is not, I'm
conflated
terrible.
two.
No,
Oh my God.
eviction is a court process.
Right,
If you don't have a landlord tenant court, then there is no place for the person to say, I'd like to go with the sheriff on this day to get my belongings. Courts coordinate when people get their
Right.
stuff and how long that takes. Ejection and eviction are two very different things. That a person under ejectment has absolutely no day in court.
They're not, they are the same thing.
that's not
under
true, I don't
Vermont.
think.
There's no difference in an ejectment or eviction.
Right.
The statute, the statutory language
Exactly.
uses the term interchangeably.
Yes, so I think.
So
every-
aren't we saying just a person facing ejectment doesn't have time to get their stuff? Or are we?
They
are we
have
shortening it?
11 days. They have a ton of time, they have a lot of time already.
They have between the notice and the last day of the warning. And then the sheriff returns and then they're out. They should be taking their possessions by that point out.
I don't even,
They've already gotten ahead.
I can't understand what the timeframes are.
We
after
just
this
heard the
explanation.
Dodgers. Gene, wait a minute, Gene has input here.
So for years, the only thing about once a tenant was gone, what was the landlord's duty was part of the abandonment statute, and landlords were required to store stuff for 60 days. And then a few years ago, this particular section got amended to say 15 days since service of the writ. So eviction, ejectment cases, the statute says that once the court decides that the judgment is for the landlord, that same day they issue a 14-day writ.
Right.
We're
We're not impinging on it.
Right. And so the thinking when they changed it to what it is today was, yes, what you're saying. The tenant has known that this is coming. They know when their final hearing is and that they should be preparing all along to leave unless they think they're going to win the eviction. The problem with the shorter time frames, the 7-day notice particularly, you can get a 7-day writ if the case is pending and there's a motion for rent into court and a rent into court is ordered and then the tenant doesn't pay the same date or the same amount as ordered, the landlord can go into court and say, I want my writ now, and can get a writ, which is just a 7-day writ, which is not the whole period of time, you know, the tenant has noticed that you're out someday. This is really a very sudden thing that happens. And so in terms of saying immediately, this really puts tenants who are subject to orders for rent and deport at a disadvantage. Oftentimes, if a tenant has been a day late or $1 short with their rent and deport payment and there's a writ issued, if the tenant can get legal help, we can go say to the court, please turn that around. Here's the money. Here's the time. Vacate the writ. But 7 days is super short. And if they can't get legal help, even if they're ready to pay, the writ is there and they lose all their belongings.
You can go the truck, move the couch.
So in terms of the immediacy, the full hearing thing, this is not much of a change. But in terms of those shorter timeframes, this is actually huge. And when not only the tenants lost their home, they've lost all their belongings.
Okay, this was a choice judiciary made.
I'm okay with being in the minority, but I'm happy to just do a straw poll on this.
This came from
What are you showing us here?
as passed by the
I'm
House.
just trying to give you a quick visual, pardon the rudimentary nature of it. The writ is served on the individual far left, okay? Under certain
So the writ
circumstances,
means the final court decision.
the court has issued that the landlord is entitled to possession of the property. And they issue the landlord the writ of possession that has to be served. So the defendant is being served with the papers that they have lost the case for argument, right?
Can I pause us here? So the section is under ejectment.
It's under the ejectment chapter.
Okay. And ejectment can happen to a tenant on a lease, a tenant without a lease, but who has been on the premises for longer than 30 days,
Be sure.
or any person. So we don't make any differentiation. This is when a sheriff shows up and physically removes you.
So that's what the
not-
red blocks
The
are.
reds are, but the
So-
first is the writ.
So
Okay.
the sheriff comes and provides the defendant who was the subject of the ejectment action
Mhm.
service that the landlord, the writ of possession, the documents that the landlord's been entitled.
Just to be clear, we haven't changed anything about any of those people's rights to a court hearing.
Correct.
Nothing has changed.
There's nothing that's
No,
been
no.
changed in the ejectment.
Okay, because then we go to the no trespass section.
Right, but we're not there.
We do change that,
Yes,
but
we'll talk about that in a second. Yes, yes. So the service is, again, it's delivered to the defendant. And then depending on, as I said.
So, and they have to find the defendant. That's also sometimes a challenge. So
Yes.
it isn't active until it's actually given and the defendant has received it. Is that correct?
Correct.
well, I mean,
Okay.
I know what sheriffs go through, but I want to make sure I understand that part.
Okay,
The
so
service is, it's hand delivery, but I can't remember now if the person has to sign or confirm that they've received it.
Chris or Jean, Cameron, do they have to, what do they have
Are we
to do
talking
to
about-
acknowledge it's been accepted?
Service of a writ,
Yes.
it's delivered by the sheriff and the sheriff is the notary and they say, I just gave them the writ. It's a proof of service.
Yeah.
I mean, this has been a debate for years. I don't know where we have landed in terms of the sheriff has to physically find the person.
Oh, yes,
to the
yes.
court.
Yes.
Okay. I thought there was something where like in 30 days that they can't find the
Okay.
person.
So the sheriff gives it to the person, they notarize it.
So it's
And-
delivered to the individual, and
Okay.
then the statute says, depending on the statutory section where the writ was issued. So whether it's because it's an unlawful occupant, because the individual didn't comply with the rent escrow into court, or simply because the plaintiff has won the case, the sheriff comes back 5 days later and physically removes that person. That's what the red bar is intended to identify. It could be 5 days, it could be 7 days, it could be 14 days. The statutory section we're referring to here says that the landlord has to maintain the property for a minimum of 15 days after service of the writ. So that's what the green
Day one.
bar is intended to identify. And so what the statute is being amended to say is upon the landlord being restored to possession, they can immediately dispose of the property. So instead of the green bar here, and under the day 5 and the day 7 scenario, the landlord has to maintain that property all the way out until day 15. And what the amendment says is no, on that day, right here,
On the
You can
final
get
day,
rid
which
of-
is 5 days or 7 days.
you could dispose of the property. So it is removing the obligation of the landlord to maintain the property out from day 5 to day 15 or day 7 to day 15 in those scenarios.
And what determines
That's
the
the
difference between 5 days and 7 days?
If the writ of possession is issued because the tenant was an unlawful occupant of the property,
Ah.
then
That's
it is a 5-day turnaround.
If it's a lawful occupant, it's a whole week.
It's 14 days unless it's because the individual didn't comply with an order of rent escrow into court, in which case it's 7 days.
So we're talking about unlawful occupants having 5 to 7 days to get out. And then lawful occupants
Could be 7
or 14.
up to 14 or longer. If
So
the court
this-
orders it to be longer.
This amendment by judiciary enables a lawful tenancy that's terminated to have 14 days to get out.
Could be as short as 7 days. The,
Might I say, if we can't understand it, I think this is the bad
Okay,
one.
Thomas, what were you say?
I understand it, and I'm about to move to strike this section, and I'd just like to have the straw poll vote move on with this. But I also want to say disposing of it means kicking it to the curb. I think they also still have the current authority to move it to a basement or somewhere else, or a storage facility to replace these time periods. They don't have to keep it in the apartment in the pristine shape, right?
Oh, yeah.
Okay, so I move to strike this section. If I lose this vote, I lose this vote.
Oh, there we are. Chris and Jean, do you have anything to add before, in terms of our understanding of this?
I think council has explained this. If you're an unlawful occupant, that means you should not have access to the property in the first place, and you have to go to court to remove you. And to have to then store your stuff, your belongings, for another 10 days beyond that period where we've already gone through a process seems like a
burden. Okay.
difficult thing.
So help me just further understand unlawful and lawful tenancy. Well, hold on, Colin. Unlawful and lawful tenancy. Once the writ is served, does the tenant become an unlawful tenant? Or are we talking about unlawful tenants from before? Because if what I'm understanding is a lawful tenant who has been ejected, it's been evicted, has up to 14 days.
you're a
So
lawful-
Thomas, it's only 1 day less than the 14,
I've been
15 days.
keeping stuff for 10, I'd actually say for 30 days in a storage unit somewhere
Yeah,
else.
but that's-
I'm not asking for that, but I'm just saying. But
It's
and
a
that's your
different-
part. You have to lose a relationship. You take on that much
Jane-
courtesy to your
Okay.
tenants.
Jean is that, had something to add.
No, I was gonna,
Oh, I
you were
thought-
talking about lawful or unlawful
Yes.
tenant, and there's a statute that defines what that is.
Right.
But I thought legislative council, it looked like he was gonna explain what that was,
Okay.
if you wanna know.
Cameron, would you be kind of, because I think that, absolutely, thank you, that's why I asked the question.
I was simply going to say you could be a lawful occupant up to 7 days after the writ is restored. Just because it's 7 days doesn't mean that you weren't a lawful occupant. The only one that's related to unlawful occupant is the 5-day period. The rest of the period is lawful.
But you're asking what makes someone a lawful or
Or
unlawful
unlawful.
occupant, and I think everyone should understand if we're voting on
Right.
this.
So a lawful tenant who is evicted is one matter. An unlawful tenant who is evicted is another matter.
But to
And an unlawful tenant is what? Thomas, have
But-
patience with us.
But to belabor the point, there are times when you have roommates and roommates move in and then they've got the stuff and the original tenants are gone and still stuff. That's stuff that people, renters need that access to. So I don't think if it's unlawful, that's any less of a reason that the landlord should not kick it to the curb right away. I think there's some obligations for the landlord to hold on to the stuff for the tenants to be able to get it over a period. So that's why I'm against this section. I'm happy to lose this vote. Happy.
Cameron, are you gonna tell us what the difference is between a lawful and unlawful?
I don't have the definition right
Okay,
now in
okay.
front of me. You don't have a lawful right to possession of the property, so.
Right,
the
so that's an
easiest-
unlawful.
The easiest scenario I can give you is somebody who has sublet who never had the legal authority to sub. So the person who's there doesn't have lawful right to be there.
I will go back to short of a no trespass and a study of landlord tenant court. And probably just a no on the whole bill because there is not even clarity on what people understand about all of the areas of landlord tenant law we are touching.
Well, there we are. So, Thomas has asked for a,
Just to move things along and just trying to be time sensitive, so.
and I think we're at the top of page 10. So are you, proposing to take this back to, a current law? I think it's current law or this proposal. Is that what you're suggesting?
Correct.
So you support current law, which requires 15 days, the landlord to take,
I would frame it as I don't support this change to current law.
so it's a pro-current law vote. Who supports current law?
Anti this change.
So wait, but let's not get into here our yes or no vote.
On
You're
what?
saying, hey,
On one. Page 10.
change storage law or don't change storage law?
I'd say that is what's in front of us.
I move to strike these changes, starting on page 10, lines 1 down through line 15.
Well, this is all current law, except for immediately. Take out the
Striking the
immediate.
changes.
So just keep current law, right?
Current law.
Okay, so who supports current law?
Current law, so striking these changes.
Okay, and who supports keeping? Okay, so,
Are you a yes on the whole bill?
well,
I mean, that's the question now.
So I think the approach of posting it apart is good.
Well, I guess what
Hopefully we
I'm
can find
saying
some
is-
common ground.
Too many things that we don't know enough about makes me a no on the whole.
okay, let's go to trespass.
Okay. Moving to the next section, we're on page 10.
Okay, we're almost halfway through.
The second half will go back. Okay, trespass. Section 4, the purpose of section 5 is to override. That's the only change here. It said overrule. The Judiciary Committee wanted to change that to override. The Vermont Supreme Court's decision in State versus Dixon allowed the landlord of dwelling unit to obtain a no trespass order, prohibiting the tenants, invitees, or licensees from entering the dwelling unit's common areas. If the person subject to the order violates terms of the lease agreement, then you have the guest.
The guest.
So then we get into section 5, which is amending the unlawful trespass section. The changes that the Judiciary Committee made here are going to be starting on page 12. So the bill as it came over from the House says that the landlord can issue a no trespass order if the tenant consents to the order, the guest has violated terms of the lease agreement, or the guest has violated state or federal law while on the property. That's still here. What the Judiciary Committee added specific language to say that the landlord can issue a no trespass order if the individual has previously been ejected from the property. And then in subdivision 2, they added language to say that for the consent of the tenant, because that's one of the conditions, you can issue the no trespass if the tenant consents. It has to be an individualized basis. It has to be on an individual case by case consent. And then it says that it's against public policy for there to be a blanket consent within a rental agreement. And any such blanket consent would be void and unenforceable. So you can't have a situation where a landlord, as part of the rental agreement, as you agree to consent to the landlord issuing a no trespass to any of your guests that they choose.
And this solves, in part, the Decker Towers issue that we had faced a couple of years ago. It's ongoing, but it's a large measure. This would help resolve those issues.
The next thing that the Judiciary Committee had was in the subdivision 3, which says that the no trespass order is enforceable for 1 year and it may be renewed for subsequent 1-year periods. The only other change is adding the definition of premises into this section. So the primary changes, as I mentioned, landlord can issue the no trespass if the person has been ejected previously. Individualized consent is required, and it's only enforceable for 1 year.
And deferential to the Judiciary Committee to apply to this section seems to be reasonable.
I would agree. They did a lot of work on this, and I would support this work. Chris and Jean?
I do too, and I just want to clarify one thing about the ability to issue a no trespass to someone that's been evicted or ejected previously. It's only under certain circumstances. It's not if you just haven't paid your rent. You can't then issue a no
No, you have
trespass.
to.
Yes.
It's gone.
It's not a no cause eviction. We can't then issue a no trespass. It's only for con that's either violent or egregious.
Yeah, very, very good point, and my apologies for missing that. When you look at the subdivision E, it is that the landlord can issue the no trespass if the guest has previously been ejected from the dwelling unit due to a termination of the rental agreement under 9 VSA 4467B. That's for the failure to comply with the material terms of the rental agreement or because of criminal, illegal drug activity, other violent acts. So it's limited to those. So if you've been ejected because you didn't pay your rent, or if you've been ejected because of a no cause eviction, then the landlord wouldn't be able to issue you a no trespass under that scenario. My apologies for not mentioning that, Chris.
Okay, so, I mean, we should very much understand this section. And, you know, to understand, the landlord tenant side of this. And when this is a big change, right? It's not just a big change for big housing providers. I want to make sure people are picturing a single family home, for instance. So often when you no trespass somebody, it's good enough to no trespass them from the common areas of a multifamily housing project, because you're saying you can't enter the front door, you can't enter the hallways, you can't be in the common areas, etc. But I need to make sure we understand this as any landlord and any dwelling unit. And that could include a single family home. And if I'm just picturing that for a minute, because that is it's a huge change to say a landlord can no trespass someone from going into someone's dwelling unit if we are not otherwise talking about any common spaces that are shared. And I doubt
Did they
Judiciary
judiciary address this?
I think the Madam Chair or Madam Senator, what I'm interpreting the point of being made is just, this is a big policy change,
it's a big
and it is.
policy change.
It's a good big policy change.
The
That's for you to decide.
do you understand fully the implications of the policy change?
Chris, can you talk with us about the single family
I
home
think it's
versus the apartment?
still, the conditions still remain. You know, you have to, the tenant that is renting the house, called the house, has to be the one that either asks, or the person that's the guest or invitee has to be breaking the law, or
Well, they have to have broken the law in the last, they violated a state or federal level on the premises.
Yep.
Is there nothing about the
or
previously been ejected?
or they're violating the terms of the lease of the lawful occupant owner, not owner, the person that's renting the place. So it's still, those conditions need to be met. So I don't see the difference between a single family home or a multifamily apartment.
No, I think that may.
I think it's still those conditions need to be.
Well, and I'm looking at the conditions, and so the tenant responsible consents to the order. Okay, you know, often that happens in situations of violence where
They don't want to. Right, the next conditions. mean-
right, so, or then they don't want to be the one to have to consent or not. The invitee or licensee subject to the order has violated the terms of the dwelling unit's lease agreement. That could be entering the basement. Honestly, I mean, lease agreements are very broad. So that is a big one. That's a big one to say, you know, like, I mean, there are so many things you could put in a lease agreement that they could violate.
But there's a long process before we get to this. And they are already in violation. I mean, if they are in violation of the trespass.
Well, actually, a no trespass doesn't take any long consideration or evidence
But
gathering.
these are mostly, these are people who have been previously ejected.
It's
Right.
not all.
So it's not all.
It's not.
It's
I just want to make sure we are understanding what we're doing. Madam
So
Chair,
it's
please.
previous, Cameron, help us.
Yes, ma'am.
Previously ejected and
So
There's no ands.
Yeah,
it's
it's
more.
it's one of those four things. It's either the tenant consents, the guest is violating the lease terms while on the
Right.
property, violating state or federal law while on the property, or the individual guest has previously been ejected. Under any of those conditions, the landlord could have a no trespass order served.
So it's the renter, it's the guest, or it's the guest who's been previously ejected.
I could maybe live with B being a pattern of violation. But otherwise, you could simply say somebody did any one of these things. They smoked outside and they could be no trespassed.
I don't think that,
That's true.
I don't know if that's true.
I hear what
Yeah.
you're saying, a pattern of smoking outside.
A pattern of violation. Of
Pattern of violation.
Of smoking
I
inside.
would be fine with that.
A pattern.
Or council can probably use a word that's appropriate to the statute.
That incorporates a pattern.
I like that.
Repeated or ongoing or, you know, this is a lease violation. It's not.
Fine.
I would probably say repeated.
Repeated.
So I just want to clarify that.
And
I think pattern is better because pattern I feel like is used in the law more than repeated.
I think that's legislative council. I think you could, well, let's come back to us with something on that. But other than that, I support this section.
I'm just reading it carefully.
Thank you, and we appreciate
It's good.
it.
It's good coverage.
And
I will say it this way, I can add the word repeatedly, and then it's a one-word fix.
okay, can you
If
read
you
the whole
wanted
thing?
to say pattern, I probably need to rewrite the whole.
Okay, so then let's just
make
add,
I'd like to say pattern.
where are you?
On line 16.
And you would add,
Rewrite it to say pattern.
he said repeatedly.
I disagree.
Well, you may be, but you're not the lawyer. Our lawyer is our
No,
legislative
what
counsel
he
who's
said was
making
he
a
could
recommendation.
just insert repeatedly, or he'd have to rewrite the whole section. And I'm proposing that a rewrite of the section is better than saying repeatedly.
Well, we have time, because we're looking obviously at other pieces. And so we're gonna end, perhaps end as we finish because we have positive rental, well, that's a whole new section. So I would suggest that we look at, Cameron, would you weigh which is better and come back to us with her,
Yeah, I'll talk to,
So we're looking at
pattern
B?
as well. I think adding pattern is going to be, challenging from a word perspective.
I'm happy to work with you on.
Okay, and so we're talking
We'll
about
see.
B, coming back to us with a rewrite on B.
Yes, ma'am.
So I would suggest that, given our time frame, that we look, we have other fairly good sized pieces in this.
So very quickly
Yeah.
to move on. So when you get
I'd
to
love,
page
this is just,
30,
let me just finish my thought here because of our time. I would really like us, if we're capable of moving out 757 this morning, we need some minutes to look at Cam's rewrite, but I think the rest of the bill is ready to go. Cameron, how much time do we need on on the airplane, on the 757 manufactured home? I think, do we need sort of 40 minutes? If we ended this discussion at 11:15, and then move to, we're starting at 11:30.
I don't think the changes I have on 775 or 757 should not take that long to review.
Okay, let's take this discussion then to 11.
Okay.
And then is that okay? And
Yeah.
then 757 to bell time. Okay, so let's finish on this.
So I'm on page 12D
Okay,
at the top.
go.
I'm gonna need to make sure I understand this one better to be comfortable with this one, because this is clearly somebody who was a neighbor in the building, and they're now no trespassed from the entire building and the person's dwelling unit.
Yes.
And it says under this and that, and I don't know if that's kind of,
Right.
all of the possibilities of why they were ejected due to a termination of a rental agreement. That could be for non-payment of rent.
But it's limited to the sub D.
Okay,
And
so that's what I'm trying to understand.
This is what the Judiciary Committee was
Okay.
looking at as well, and so you're correct, Madam Senator. It is the individual, the guest, has previously been ejected from a dwelling unit on the premises. So it could have been someone's neighbor, probably the most likely scenario.
Mhm.
And
That's what we looked at
due
with Deckard.
due to a termination of a rental agreement under 4467B. So
Okay.
the committee had that discussion that you were just raising. Some of the senators on the committee said, why would we allow the exclusion of the individual as a guest because they were evicted due to a no cause eviction,
Right.
for example?
Right.
And so the committee decided to limit it to just termination under the breach of the rental agreement, the
Mhm.
subsection B. So it has to be a termination because the tenant is failing to comply with material terms of the rental agreement or with the obligations imposed under the chapter, or because the termination is based on criminal activity, illegal drug activity, or acts of violence which threaten the health or safety of other residents.
Mhm.
If the ejectment is under one of those two scenarios, or one of those two reasons for termination, then the landlord could issue a no trespass order.
So for the same reason that I struggle with B, I would limit this to B2.
Further limiting it. It's a policy decision for you all. You all as the general assembly.
Was it a good or a bad policy?
Not my decision, sir.
Okay, let's
So
keep,
if we're straw polling, I agree with Senator.
I'm not sure I fully understand.
I'd love to see that language come back. Are you
Yeah.
thinking Monday that we're gonna work on this?
We're meeting Monday at the moment on 2:30. There are lots of concerns about
Page 205 discussion.
So we are still.
no, I had just said it was
Zoom.
voting.
Zoom.
Like,
Yeah. Okay.
The one thing I'd like to stay on this before we talk about 2:30. So, can you just explain what you just suggested, Keisha?
That we write B2, that we limit the ejection to violence.
So it would be, on this line 3, it would simply be
So
adding.
I'm sorry, are we on page 12? Are we back on page?
Page 12,
11.
line 3.
Page 12, line 3, we would add 2 after 4467B, so it would be 4467B2. And that would further limit the ability of the landlord to issue the no trespass due to an ejection to only ejectment actions that are brought based on criminal activity, illegal drug activity, or acts of violence which threaten the health or safety of other.
Fine with it. Were there reasons that wasn't included, Chris?
I think this is the intent. What
Okay,
what you're
that's the
talking about is
intent.
the
Okay,
intent.
So it would read 4467
B2.
B2. Great, fine.
Okay.
And then we're going to look at, language on repeated and,
Repeated versus that.
okay.
So,
Let's move then to positive rental payment.
so the.
Oh, do you want to do a straw poll?
No, I
I'd
think
wait
we're done as,
straw poll till we have one.
I'm still reading.
unless we want a straw poll.
I'd like to see the language on case.
And I would just like to flag for finance that this has a different definition of dwelling unit than what you're looking at in 955.
Consistent with like lawyer's point.
Nuts.
I know, but that is an undecided thing. We have to move on.
I'm just flagging it for that.
Okay, fine. Let's move to
So-
positive rental agreement.
Page 13, all the way through page 17 is the positive rental payment pilot program that I think you're all really familiar with, which
Yeah.
would be out of the Office of the State Treasurer. My recommendation to you at this point is if you're not funding the program in the budget, I would simply remove this because it has the language that says there's no obligation to do the pilot if there's no funding. I think the State Treasurer's Office has been very clear. They can't do the pilot without funding. So
Yeah,
keep it. I think it's confusing for the public if you have it here, if you
I
haven't
agree.
actually funded it.
I need clarity though. This was, I believe, included in the House budget. I know it wasn't included in either budget.
Governor's budget,
Not to my knowledge.
No, not definitely.
Senate budget.
Not to my knowledge.
So then I would take it out.
The only thing I will
It's a
offer.
great program. I think this is,
Because the treasurer has been good at these things in the past, though it has been frustrating when we did baby bonds, is that we allow them to accept a non-state funded contribution toward achieving this pilot. They're not in the room, so I would just offer that that is something we can do when we can't come up with the money, is see if they can get a economic empowerment foundation to do this kind of thing, for example, or a donor. But because I have always cared about the section, I
we
used it the
all,
first time.
I will,
a
if
lot
you're
of
okay with
us
it, I mean, I will
supported
send
this
them-
section.
I will ask them.
So why don't you ask them and see if they are okay with that? Otherwise, let's
And
start.
you may have, I mean,
Other,
you
yeah,
may have 3 members who are not okay, even if it's funded by somebody else. But that is something I'd like to put on the table.
if you'd be kind enough to check that with the treasurer's office, that would be great.
Yes, ma'am.
Because there are at least 2 of us who have supported this from the beginning. It's a very, I mean,
Not
really is a great way for renters to build credit score, given that we've just talked about credit score and how important it is for getting a bloody apartment in the first place. So,
Good, so
Let's
now we're on
move.
page 17, the bottom of page 17.
oh my God, we're like racing.
There's a section related to the security deposit transition period, which is intended to say that if a landlord has a security deposit that exceeds the 2 months rent, so you're putting the cap in statute of 2 months rent. If a landlord has a security deposit that is more than 2 months rent, the landlord can maintain that security deposit until the termination of the rental agreement, if the rental agreement was in effect prior to the effective date of the act. It's just saying if you're holding someone's security deposit that's greater than the 2 months rent, you don't need to give part of that back to them to be in compliance with that section. Simply have to comply with the security deposit law and provide it back to that person upon the termination.
And once again, a no on changing security deposit law because it affects a lot of other areas of law.
Yeah,
So-
that section kind of corresponds with the security deposit above. If you're gonna take that out or change that, then
So what did judiciary do with this?
they made some minor changes based on.
But they kept it. They supported it by keeping it,
Well, I think this is an area that they feel is the jurisdiction
even though
of
it's
this
in
committee.
their purview.
without endorsement, they've sent it to us.
I think they would say it's in your jurisdiction, not their jurisdiction. I don't want to speak for them, but
Did we straw poll to remove the 2 months thing earlier?
you did not.
Okay,
We
we should do that. And,
Okay, the next piece of, to keep going real quick to get to the end, page 18, next section is the landlord and technical education and the landlord and tenant education and
Yeah,
technical
this is
assistance
so
program, the CBOEO, similar to the pilot program for credit reporting. My understanding is this was not funded in the budget, and if that is the case, my recommendation to you would be to remove the language.
was it contingent upon being funded? Because I believe there is some work already going on in terms of landlord tenant education. Chris or Jean, anybody who knows about this, I think there's some work going on this.
This was, all I know is this was not funded in the budget.
Right,
But okay, I'll
but
just
it's
say,
still a good thing to move forward with.
it took me until this year to realize this is Tenants Inc., right? Like, which was called 20 years ago when it was at Legal Aid. It is the only hotline. It now is housed in CVOEO. It's the only hotline where people can get information about their rights and responsibilities.
It's a great program.
Don't you have a hotline?
Great program.
Doesn't Legal Aid have one?
I would say as of this moment, we're not very hot with answering the questions because
You're overwhelmed.
Legal Services Vermont has lost funding on legal aid. It has lost funding. So no, we're not answering the phone for all the questions. People call and we call them back. Right. That's not,
So at the moment, CVOEO is taking this on or not? Have they done it and no longer doing it?
Well, they have taken over this tenant, this tenant legal info, like they,
Because they testified.
well, I'm trying to understand, once it left legal aid, if they're obligated to, if they have a lawyer on staff, so they're not providing legal advice, they're just providing information about the law.
And resources of it to,
And this
Go
whole
to-
section's contingent on an appropriation, which doesn't exist. I was worried that they are unfunded or losing funding for
No.
the hotline,
I don't think
but
so.
they
is saying
certainly
that.
can't do anything.
So-
about.
But this is a need that needs, so this is maybe another piece for the court to look at it, like how do we addressing needs in a
Okay,
place for people to.
yeah, courts don't do that.
Well, courts are being asked to do a lot here, you'll see in the report. Okay, so our next is our housing court study.
Technical training, do you want to keep this in or remove it?
Sorry, technical training, I think remove it with no funding.
Okay.
Is that okay with everybody?
What?
Remove section
Okay.
9 with no funding.
Okay, so now we get to the statewide housing court report, section 11 on page 19. On or before January 31st, 2027, court administrator shall submit to the General Assembly a report on the feasibility of implementing a dedicated docket in Vermont for handling all matters governing residential rental agreements under 9 VSA Chapter 137 and injectment actions under 12 VSA Chapter 169. The report shall include an examination of.
Can I ask a question before we go on?
Sure.
Did they, I'm just curious, did they have a discussion of just focusing on residential rental agreements?
Not while I was in the.
Okay, I think that's the best practice. I just,
Okay, then we can testify with the court in the course of their work. I think that we can.
are we having them in?
No, I don't think, unless people feel we have to. I think that this is the work judiciary did.
Well, it does say page 19, line 5, governing residential.
No, that I circled that. That's what I'm saying. So it's, I just didn't know if they had discussion about other landlord tenant law, which
I think,
governs non-residential.
right, but this is the majority, I think, of the concerns in this bill.
I know, I'm just wondering if they had a conversation, and I do think we need to talk to Sherry.
You can talk to Nutter and ask her.
Are we gonna have Judge Somay?
No, we're gonna try and move this bill in the next couple of days after we address the issues that we have. And it is Terry's charge. And I believe Terry has taken this on and I think that we,
Oh, Terry Corsons. It was like Terry Will, like I'm.
No. Really, there's no issue positive or negative. We're just, an indicator.
I don't know.
well, we can ask Nutter.
We can't go to the. Well,
I mean,
this.
Of course
We'll see.
not,
That
but
should
I
be how
believe it
talking
wouldn't
to
be
the
here if the court had objected.
I've been asking for a month or more to have the court come in and testify.
I know we're under it.
No, we're.
This is a great, potentially a great opportunity to create
Agreed.
this. It would be possibly appropriate to have someone sitting in the
Absolutely, we'll
chair.
have Terry Corzone in. Absolutely happy to have Terry Corzone. But I'm just saying,
I
let's,
don't think it's a great idea. I think we ought to ask them before we try to present something on the.
right,
And we
of
don't
course,
know.
of course, but we have a lot of other things we're coming back to review. Clearly, we're not passing this out today. Give me a break. So would you be kind enough, Cameron, to just finish this section?
Yes, so the first thing the report will look at, financial costs of implementing a dedicated housing docket in Vermont. Workforce impact of a dedicated housing docket, including the number of judges and staff necessary to resolve all ejectment actions statewide within 90 days following the filing of the complaint. Meet the timelines outlined in 12 VSA Chapter 169 for expedited hearings. And resolve ejectment actions brought due to the termination of a rental agreement under B2 within 21 days from the date of filing of the complaint.
Okay, so
That-
this, sorry. It's called a residential rental agreement docket in the first paragraph, and then the rest of it calls it a housing docket.
So I just referred to it as a dedicated docket in the first section for handling matters of residential rental agreement, and then referred to it as the housing docket throughout. We can take out housing if.
No, I think I think many of us would like to have a complete housing docket.
That is a policy question
Right.
that,
And that is our discussion. I think that's our discussion.
So I would say you're limiting what they're looking at as far as what you want to title the docket. This is just the report.
Well, the housing
So
report.
you would obviously title it whatever you all would prefer if you put something in statute separately.
I mean, I would say, let's say we're just talking about what it should be called in the future, like LUR. It is concerning to call it a housing docket while we have the environmental court and while we have other housing matters taken up. I think most states call it eviction diversion or some other form of discussion of residential rental agreements, if that's what this is limited to. I'm not comfortable.
Fine, we're putting a pin in and we're
And I'm
inviting
not-
Terry and
Yeah.
we will
Yeah,
chat about
I
it.
hope we don't feel like personally
No.
anything, Cameron. I'm struggling with the building.
You call it whatever docket
She
you
is
would like.
just struggling with this bill
Yes.
period.
Okay.
Is
So-
it clearly, I mean, the housing, I think in all fairness, this committee has supported the notion of a housing court for a long time that would see your appeals. It would be a much bigger
Yeah.
court. So some of us are very keen on that long term.
Well,
Right now,
Different
we're
thing.
dealing with landlord tenant law.
Right.
We're looking at a rental,
right.
more a very focused rental docket at the moment that could perhaps, given
And-
time and resources, be expanded.
I just want to make sure that people are also appreciating the full scope that, for example, Burlington has a tiny quasi judicial entity called a housing review board, but they almost exclusively focus on security deposits. They do not handle other
Right.
matters. So we really should try and make sure at some point we're on the same page about
Right.
what this diversion board would be.
So, we gotta finish because we're gonna try and get.
So
757
what
or maybe
the
775.
report is intended to look at is resolving all ejectment actions statewide 90
Right.
days, complying with the current expedited hearing timeframes, and then creating a further expedited hearing for the terminations under B2 within 21 days. Also looking at the impact of other court staff with the implementation of this dedicated, I'll just call it docket for now. Moving to page 20, whether current state facilities have the capacity to support, whether new or expanded facilities would be required, whether current technical capabilities within the judiciary can handle virtual statewide implementation, and any other matter deemed relevant to the issues of implementing a statewide housing docket, or whatever you want to call it. Sub B here, the report shall include information on legal issues to consider and requiring an expedited hearing for ejectment action brought due to termination of a residential rental agreement under B2, including how the court would determine that a tenant is an ongoing threat to the health or safety of others, if that were to be a condition upon which an expedited hearing would be allowed. So there was discussion in the Judiciary Committee about limiting those ejectments that are due to some sort of violent acts, of whether those acts should be
Yeah, but
of an
this-
ongoing nature,
Dangerous, yeah, this is the dangerous tenant.
and whether it should have to be an ongoing threat to the other individuals. And so they're asking, or the intention of this language was to ask the court to provide you all with information on how the court would go about making that determination
Right.
in an expedited hearing.
So this was, instead of addressing the dangerous tenant, they chose to put this into the court studies.
So on page 20, line 6 and 7, I would just want to make this more specific in terms of if they're gonna go beyond the scope of residential rental agreements.
Let's, for the moment, look at this and figure out the language around a residential rental docket. Because it's, I think.
Well, but even if we
term-
call it a residential rental, matters residential rental, I want the court to be able to come back and say, you know, we feel like if we went through all this trouble, we want to go beyond residential rental to landlord tenant law.
Include that as part of the report. You're
That's
saying
right.
like whether or not to include additional matters
Yes.
within this.
Yeah, I don't like.
Within the
whole,
entire
like,
purview
you know,
of land.
is there anything you'd like to add? We could say that, but I would change that section or make it more specific to. Do they think this court should have a scope beyond residential rental agreements?
Okay.
Let's finish up and then let's. Okay, I think we're on B. We were on B4, or have we turned the page?
No, I believe that's where we're at. So looking
And then
at,
B at the
how to
bottom.
determine, this is under the sub B 1, 2, 3, 4, how to determine if it's an ongoing threat for the expedited hearing.
Right.
Whether there are procedural issues with beginning the time frame with the filing of the complaint versus service of the answer. How the court would determine that damage to the dwelling unit is a threat to the health or safety of others. That was discussion among the judiciary committee about whether or not damage to the dwelling
It's
unit.
not
should
just damage to the dwelling unit,
Right.
it's damage to the whole community, as we heard from Gene. We had the best testimony on this from Gene Rissman.
So under B2, where it says criminal activity, illegal drug activity, or acts of violence, there was proposal on the House side to include the words damage to the dwelling unit.
Right.
And there was discussion among the Judiciary Committee about whether or not damage to the dwelling unit should rise to the level of having an expedited hearing within 21 days. And
Yeah.
how does damage to the dwelling unit actually threaten other people?
Right.
So that's what this is intended to get at.
The residents of the damn unit.
And then whether there are procedural issues with shortening the time frame for termination of the residential rental agreement. And
Yeah.
moving to the top of page 21, in developing the report, the court administrator shall work to balance the needs of interested parties and making its recommendations, including balancing the rights of tenants, the landlord's property interests, and the safety of other tenants.
Okay, thank you.
Dated July 1, 20.
Terrific. Thank you. I think just given all that we're to go to Monday, so we're meeting Monday, 9 to 11 on Zoom. We had intended to just address S230. I would propose that we spend the first hour addressing S230 and the pluses and minuses of including the change that the House made to include non-competes, or whether we, it's extremely thorny. And as both the chair and vice chair, we're going to have the chair of House Commerce in to talk about how full that field is of mines. So it is a minefield that we may or may not have time to address and actually deal with that next year. The other half of it, I would propose we begin to look at the changes in this bill and have Terry Corzones come in to discuss the court study and to address the other changes that we have discussed and begin that discussion. Then on Tuesday, we have a PBD at the moment, correct? And we'll do this bill at that time also. We'll have an hour to do it. We only get an hour and a half each day unless you're willing to start at 8 a.m. on Wednesday and Thursday.
So then I would just, I think I was the one trying to untie the knot on the non-competes. And like, if the whole conversation is, are we gonna do it this year or not?
Yeah.
That time might be better spent on this if I'm the only one who was trying to to
Well, I think
do
Thomas had some
something
interest.
here. I mean, but I'm rethinking how much time we spend on that if you actually want to vote positively.
Right, so I think we need, there are two things in front of us on S 230. Hold on one second. One is the non-competes that have been raised, which is evidently a much bigger conversation, and particularly if we want to talk about features, it's evidently ripe with challenge. And the second, which we'll hear about, but the second is the VSDA request. And it's got, and Sophie may have a way for us to work that through, although sadly, we have heard from Bloomer, we did go and discuss whether it was germane to the bill, the labor bill we have at the moment. So it has been, John felt it was probably not germane. We can, as a committee, of course, decide that it is. I just wanted to put that out there for you as we talk about it. I would give, if we're not going to discuss the non-competes, and I'd love input on this, we could do 45 minutes on 230, and the rest on housing. On
What's 230? I thought that was not.
no, it's the labor bill. It's got other pieces in it, and it's got the request about the VSEA. So I mean, we have to land agreeing with the House or not agreeing with the House, and then I would devote the rest of the time to doing 772. I'm not gonna, and then hopefully we can do 757 right now, and then we can finish up on 775 on Wednesday. And we also have S 327 coming our way, the economic development bill, and we will at some point have the S 328, the housing bill, coming back to us for that. So we have to deal with all those. I think we have permission to go through Friday for an hour and a half each day, unless people, I would ask them to think about Wednesday, Thursday, Friday, starting at 8 if you wanted. But I can appreciate if 8 is too
make
much.
that commitment on Friday.
Too, so.
Yeah.
I know, and I know we're gonna have conference committees,
Yeah.
and so we're gonna have to work around that too.
Yeah.
So at the moment, we're scheduled for 8:30 to 10, because floor is 10 o'clock every day. On Tuesday, however, given many of us are commuting up to the State House,
Kira, can you do calendar invites for each of those days with Zoom links embedded in them?
yeah, because sometimes you have to be on the way. I appreciate that. Unless people want to start at 8:30 on Tuesday. But I'm happy to start 9 to 10 Tuesday. We're doing 9 to 11 on Monday, and then 8:30 to 10 each of the other days.
And I might be a little late on Monday. It's sibling teacher day under child care. So
It's not sibling on.
It's
You
someone.
know, you got to count prep. Okay. So, okay. So we're ready to shake up our brains and go back to, Bill, I think we're ready to land.
which is not my.
It's the airplane. That's why I'm using the airplane language, 757. It is the manufactured housing bill. We heard from Gail yesterday, and we asked Cameron to draft some continued work on this because it's unresolved. These corporations, David Hall made it very clear that these are for-profit businesses functioning and hoping always to be considered nonprofits. And so to that end, I think we agree to move ahead with the way things are happening currently, clarifying that, and then asking for this additional work to be done. Cameron, would you be kind enough to address where we are and David Hall's feedback also, and the suggestion of a way to look, who's going to look at it and come back to us with record.
Sure. Yeah, so I drafted up an amendment based on the conversation that you all had yesterday, but had a conversation with David Hall, and just wanted to clarify a few pieces.
Thank you.
For the discussion.
Thank you, everybody. Have a good weekend.
So in 757, we're talking about the limited equity cooperative mobile home parks, right?
Yeah,
And there was a question, a discussion about some of them are listed as nonprofit entities of the Secretary of State, some of them are not. Discussion about that indication of nonprofit status being able to allow those entities access to funds that other entities may struggle to access. And so trying to resolve that issue. And there was conversation, you've had conversation a few times now about, well, why aren't we just registering them as nonprofits? They do serve a public purpose. In statute, that is listed what the public purpose is. These entities cannot be listed in the Secretary of State's business registration system as nonprofit entities because they are not organized as a nonprofit corporation. Separate from that is an entirely separate thing of whether they get tax exempt status with the IRS. That is not a state matter.
right.
That
That
has
is
nothing
not
to do with us.
necessary to be able to be considered, but we don't know that fully, which is part of why we're asking for this.
The organization of a nonprofit at the state level is about how the corporate entity is set up and how it operates. And so the Secretary of State's office at this point is being very clear that these entities are not nonprofit organization types, and they're not designed to be, and the statute doesn't allow them to be nonprofits. Why are some of them registered that way? I think they've testified pretty clearly that that is an error that was
Historical
done.
failure is what I.
Right, and so it is somewhat problematic to just unilaterally go in and then alter certain things within the
Right.
registration organization. So you don't want to do that. The point I'm just making is this discussion and this point about should they be all made to be nonprofits, except for they shouldn't, because their organization type in your statutes is a cooperative housing corporation. That's what they are. And that's what the Secretary of State's office is organizing them as at this point moving forward. So then you get the question of, well, we want to make sure that they can access certain funding sources that the state offers. How do we make
And that's a whole
sure?
range. Remember, that could be AOT for a road, and
Exactly.
that could be water, sewer.
Exactly.
It could be lighting, it could be internet. There's a whole range of grant opportunities they might be.
And so the question is really dependent on what those funding sources are designed to provide money for. Do they require tax exempt status? Do they require some sort of service of a public purpose, et cetera? It's going to be dependent on whatever that funding source is. So what we've done, this
Or
amendment.
the population it serves, because
Right.
as we have discovered, the equity limited cooperatives are for housing of low and moderate income people. That makes many of these communities eligible for some of these grants, independent of their technical corporate status.
Could, it could.
But possible.
So.
But all of this is clear as mud.
Right. So what I've done, based on the conversation that you all were having, is I've done a few amendments. First off, first amendment here. So we're just looking at what the amendment would be if you all wanted to amend the bill. First, you'd be adding in a sunset. Removing this.
That was Randy's idea.
So you've added, so the bill adds in this B1, which says that a mobile home park that is a limited equity cooperative shall be treated for purposes of state funding and grants as if it were incorporated as a state nonprofit corporation for public purpose and public benefit under the laws of the state. That will resolve the problem if the funding source requires that the entity receiving the funding be organized at the state level as a nonprofit. That would solve that problem. But as we've discussed, without knowing what all these funding sources are and without knowing what all their eligibility requirements are, et cetera, it may not solve the problem for certain funding opportunities. It may not. All this section is saying is you're going to be treated as if you're incorporated as a nonprofit for state funding and grants. Give you an example. Let's say the state funding and grant says you can't give the money to a state nonprofit. I can't imagine why a state funding source would do that, but just humor me. If the funding source says this money doesn't go to state nonprofit entities, this section isn't going to help them access those dollars. Okay, so you have this in. Here's the sunset that's being added. Separate from that, you have this report. Second instance of amendment, new section, section 8 report. Department of Housing and Community Development, November 15, 2026, in consultation with the Agency of Administration, ANR, AOT, shall submit a written report to the committees of jurisdiction here, identifying all state funding grant and loan programs available to mobile home parks for infrastructure improvements, with an analysis on the eligibility and regulatory barriers prohibiting access to the funds for mobile home parks registered as limited equity cooperatives. You want the answer to what are the barriers for these organization types to be able to access state funding and grants. That's what that report is specifically intended to give you the information on. What are the fundings and what are the barriers that are prohibiting these entities from access?
That is what,
I added in that the Secretary of State should provide technical support as necessary to DHCD. I have not run this by the Secretary of State. I haven't run this by DHCD. So,
Right.
so you know, I don't know whether
but
they can support
DHCD
it.
has a mobile home park unit.
Yes, ma'am, they do.
And they are
They
the
do.
best equipped to really take leadership of this.
And so my thought was, the reason I added the B was if they're doing an analysis of the eligibility and regulatory barriers that may prohibit access for these entities, the Secretary of State's office could help them identify what these entities
And we
are.
also talked about tax, the tax department.
So, yes, ma'am, in discussing with you first thing before testimony this morning, I realized I had not included the Department of Tax. If you feel that that would be, although the Department of Taxes exists under the Agency of Administration. So I think you're actually okay.
Oh, okay, right. We have in consultation with the Agency of Administration, right?
Okay, and so then the third instance of amendment, we've changed the effective date because you got that sunset. So effective date's July 1, except 5 and 6, which relate to sales and use tax. This is as the
Right.
bill came over. This hasn't been
And
changed.
remember,
What I
we
had
have
to do,
electric fees that finance is going to.
what I had to do was add the lines 3 there. So the and section 3A, which is the repeal, takes effect July 1, 2028. It's a 2-year sunset. So you get the report back, gives you a biennium to potentially either keep the language if you feel that that's the best way of addressing the barriers that these entities face, or it gives you the biennium to target those grant and funding opportunities if you feel that there's something that needs to be changed.
Or if you just look at that, is how much money we're gonna lose by virtue of the fact that it's gonna take us 2 years to fix this. That just seems like an excessive amount of time. And one of the questions is this the kind of thing you do a summer committee for, and you're ready to go next year, done with it. That's a year. I don't know how much money we're talking about. That's again something I would know, but why do we have to fool with this thing for 2 years before they get it just in place?
Well, we're not, we're asking it back this November.
But I think you're putting this in place
Yeah.
with the possible sunset in 2 years and asking for the report. And Senator, I'm going to speak for you, but I assume what you're saying is like, hey, let's just get the information over the summer and come back and fix it once.
And then,
To be ready.
but so get rid of the sunset.
Well, no, put the sunset in, because it should go away then. But just.
No, what should go away? I mean, hopefully, once we fix it, this is an opportunity. We want everyone who has a limited equity cooperative to be able to participate. I mean, take advantage.
I agree. I agree.
Yeah, so I would say the report's enough and then get rid of the sunset. I would support that.
I got the impression you want to keep the sunset in case there's the issue with adding this into statute.
Okay, then if we're gonna keep this done,
Sunset.
I would put in 27 after they've done this report and after we've hopefully changed the law. See how it's working. Is that okay?
That was the intent. Was
Right.
The sunset was to force us to get on with it rather than dragging it out.
Got it.
That was the
No,
purpose.
no, I appreciate it. And that's why we have the date on the report.
So you want the sunset to be 27? not
Correct.
20. Is that?
I think that makes
That may have been
sense.
just a misunderstanding on my part.
I don't think we were fully clear at that one. So, yeah, I think we're getting there.
Okay, so I will change that to 2027.
I would, welcome a motion, to move H757 as amended with in the first, second, in the second, third, yes. Third in the three instances of amendment with, and they would be draft
I'm gonna do it as 1.2,
1.2.
would be dated May 8th.
Oh my God.
Moved as described by the chair.
Does that work?
What?
I said so moved as described by the chair.
So moved as described by the chair. I would accept that motion. Senator Clerk. And with the understanding this, the fees, all the fees that are discussed in this bill are going to finance. And we sort of agree, given our time frame, let them be able,
So this is.
So this bill's going to fight.
yes.
It will, yes. Could be draft 1.2.
Thomas Weeks, you have coffee. Senator Weeks,
Just want to make sure so the amendment is 1.2. The bill that we're laying the amendment on top of is draft 2.2.
is H757 as passed by the House.
Okay, so I vote in support. Okay, to Senator Brock,
Yes.
Senator Chipman, yep, Senator Robinson,
Yes.
Senator Wiggins, yes, Senator Coates.
Yes. Who would like to report? I've already taken on one bill that no one else
I
wanted
haven't
to
taken one, so glad to do it. Unless somebody else really wants
Good
it.
man.
Thomas Chittenden, we thank you.
I'm gonna need a really good section.
Yeah, right, exactly. And David Holzletter. Want to be,
That one sentence, section.
Yes.
for all of it. We are very grateful for sections by sections, in case we haven't already said. Thank you to Ken.
Would you like me to now pivot you to 775? Or
I
are you
think we
feeling
have
a
had a
little
long morning.
punch down?
We have
on it?
5 minutes to go. Anyway.
We have 6 minutes before we're
You
due.
have great endurance and stamina, Doug Cameron. Thank you for all of this.
Yeah, we're very grateful. I, as much as I would love to get 775 out of here. I mean, if, I just, if we wanted to quickly review, I mean, we do have a few minutes.
What is?
It's the housing bill, but it's the housing bill. And we have made a number of changes to it and. I think we just are gonna need some time to review it, Cameron, if you don't mind. I think we will do that on. We'll figure out which day to do it on.
Yes, ma'am.
And I,
Totally understood.
I just can't stress enough, like, even if the Zoom links populate every next day, I need this on my calendar so nobody else asks me.
I can't help you
I'll
with that,
just put it
but
on.
Karen can.
Yeah, right now, because
So we will take this up either Monday or Tuesday, just with Cameron, if we could do a quick review.
Yes, ma'am. Just remember, I will be
You're not available Tuesday.
Tuesday, yes, ma'am. But Monday is just fine for me.
Monday's fine. Oh, so Tuesday you can't be here with that. So we will do other non-housing things. We'll have,
Yes.
so we. Okay, we'll do. Okay, thank you.
Can
I
we-
forgot.
can I make another request here? Can we get
I'm gonna go to my next
an
meeting.
agenda,
Have a wonderful morning.
even if it's tentative, but an
For what
agenda
remains of it.
for the day?
Yeah, we'll have it by the end of
I
today.
mean, in the calendar, because I bet it will keep changing and That's what I used to do, because it was really helpful to have the changed agenda, especially from out here in person on Monday. To have the most up-to-date agenda in the.
We have been trying to do that online, obviously, for all of us to just check it online. Are you asking to incorporate it
Oh,
into?
yeah,
Into the calendar.
I agree with you.
Yeah.
Regarding, good.
Great, let's go.